workshop about the practical obstacles and the legal issues arising in the implementation of the regulation. The aim of today is trying to understand which is the situation in the implementation of the regulation, or which is the practice in the mutual recognition of freezing and confiscation orders in our 10 member states. And above all, we would like to understand which are the problems, which are the ground for refusal, which are also the practical obstacles, so for example, problems on translation, or problems connected with the forms of confiscation which is involved, in particular confiscation without conviction, extended confiscation. In the end, we would like to, first of all, better knowing our system of law and the implementation of the regulation in our systems, and we would like also to elaborate some solution to the problems, to stress the best practice in the implementation of the regulation, and try also to elaborate some guidelines for the future, or reform proposal if in the end we evaluate that there is this some necessity in this direction. Today I ask the authorization for to record our workshop and to publish in the end also the results, the transcription of this workshop in our database. Amalia, we have something other to say in the beginning to
no.
Remember?
No.
In the end, I would like also to speak with the other member or the partners, the opportunity or the possibility to deep our research through a very brief questionnaire for public prosecutor or for the authorities that who are involved in each member state in the implementation of the regulation. Matteo and Pietro, Anastasia and Pietro Insolera, prepared a brief questionnaire in order to involve also in each member state a limited number of authorities directly involved in the implementation for a really brief interview to this questionnaire to better understand the problems in the practice. In the end, I would like to show you this questionnaire and to evaluate the opportunity to send to the authorities involved. Okay, for now, I would like to start our. This is a workshop. It is not a conference. We wanted to understand and to work together to find solution, best practice, and so on. So what is very important is the debate. After each speech of a representative of each member state, we have to have a debate together in order to do our research. Okay, so in order to start the first speech, okay, is of a representative of the Italian Ministry of Justice, Dr. Michele Fini. Michele?
Good morning, everyone. Can you hear me?
Okay, give you the floor. Thank you so much for your participation and for the participation of the Ministry of Justice in this project. For us, it is very important, the support of the Ministry of Justice. Thank you so much. I give you the floor. Please.
Thank you very much, Anna Maria. You're very welcome, and I feel really honored to take part in this so important workshop. If you agree, I will just give some brief description of the Italian system and so the main features of the way in this moment currently we are implementing the regulation. Then I transmitted in the past days a couple of statistics regarding both passive cases and active cases. So maybe when getting to that point, you can also show the other participants the results of the survey we carried out. And then we will be focusing on the main topics of the workshop, the challenges we are facing. So we have been facing so far while giving our assistance to the judicial authorities involved in the recognition and enforcement of the passive certificates, as well as in the issuance of the active certificates. So talking about the main features of the Italian system related to the implementation and application of the regulation on issue, I would say that we can talk about 4 different aspects, which are the competent authority in order to recognize and execute on the one hand, and to issue on the other hand the certificates, both the freezing certificates and also the confiscation certificates. The allegation of the orders, confiscation and confiscation orders, on the basis of which the certificates have to be issued, the channel of communication and assistance which the competent authorities, Italian authorities, but also international European authorities are called on to provide for the judicial authorities involved in the proceedings. So it is interesting when it comes to the competent authorities in order to issue or to recognize or receive the certificates, give some at the moment just some brief overview of the draft legislative decree, which is on the way to go through in order to implement and to adapt the Italian legislation to the regulation itself. In the draft legislative decree, 4 different options have been adopted when it comes to the different kind of certificates coming into issue. So I'm referring namely to the solution, the option for the freezing when Italy is the executing state, then the confiscation still with Italy as an executing state, but also freezing and confiscation when it comes to cases when Italy is the issuing state. So for as regards the confiscation certificate with Italy as an executing state, the solution is a multiple solution. It means that there is a main different criteria in order of the possibility to actually apply them. It means that the first reference has to be made to the district judge for the preliminary investigation, who is competent as regards the good at issue or the debt debtor at issue. And in this regard, I wanted to specify that when I'm talking about district judge for preliminary investigation, this is mainly, of course, for people not coming from from Italy, for foreign people. When we refer to district judge or district prosecutor, we are talking about the judge or the prosecutor who sit in the main city of the district of Court of Appeal, where in this case the good or the debtor are. So just to simplify, if the good is in the province of Naples, for example, in Avellino, the district judge for preliminary investigation won't be the judge who sits in Avellino, but the judge, the district judge for preliminary investigation who sits in Naples, which is the main district of the district of Court of Appeal thereof, which is the Court of Appeal of Naples. So when this is not applicable, I mean the first criteria, the first reference, the judge for the district judge for preliminary investigation who is competent on the good or on the debtor. The second one, just in case the first one is not applicable, is this district judge for preliminary investigation competent on the residence of the debtor or on the or where the company has been established. Whether this is not applicable either, the third referral is to the district judge for preliminary investigation, where most goods or most debtors are located. And the last one is the district judge for preliminary investigation competent on the good or on the debt, the more valuable good or debt. A similar option has been adopted when it comes to confiscation certificates, when Italy has to be regarded as an executing state. Instead of the referral to the judge for a preliminary investigation, of course, the referral has to be made to the Court of Appeal, the competent Court of Appeal, but more or less with the same different criteria I just named. With the last one, which is the very last one, and which is applicable only where the previous ones are not applicable, which is the referral to the Court of Appeal of Rome, which in our system, generally talking, as when it comes to international functions, competencies, as a kind of ultimate competence. When it comes to Italy as an issuing state, we, of course, we have in the draft legislative decree other solutions, specific solutions for the cases of freezing and confiscation. And when it comes as regards the freezing certificate, the competent authority for the emission is the same authority who actually issued the order on the basis of which the certificate has been issued, namely the public prosecutor or the judge for preliminary investigation, or anyway the judge. This is because in our system the preventative seizure, which is the freezing itself, as be regarded as the freezing itself, can be also issued by the public prosecutor. Of course, in this case, the order has to be validated within the set deadline by a judge for preliminary investigation. But this is not something which at this stage seems to be to make not applicable the provision also with regard to public prosecutor, who can actually, apart from issue the confiscation or freezing order, issue the certificate thereof. A similar solution has been also used, sorted out with regard to the confiscation certificates. In this case, of course, the confiscation order is issued only by the competent Court of Appeal, but the solution adopted as regards the issuance of the certificate thereof is the one which provides for the public prosecutor to issue the certificate in two different cases. Of course, when it comes to confiscation, criminal confiscation, the proper criminal confiscation, the prosecutor at the so-called executing judge is competent, while when it comes to non-conviction based confiscation, the competence will be on the public prosecutor at working before the court which has issued the confiscation order. Still navigating, still talking between the current legislation and the way forward, the incoming legislation, we can focus on now on the channel of communication. There is, of course, two main options, with both of them with upsides and downsides. Of course, is there any question? I see some guests raising their hands. Or maybe not for me. No, okay.
No.
Okay, great. Anyway, this is, of course, as Anna Maria said, this is just a workshop, so feel free to interrupt me and to ask for any kind of clarification, even throughout my intervention. The two different modes are, of course, the communication throughout the central authorities and direct communication between judicial authorities. Of course, in our system, a lot of many, not everyone, actually not every of them, European instruments, also the one based on the mutual recognition, avail themselves of the cooperation and assistance provided for by the Minister of Justice as a central authority. And this is also something very valuable for us, because we can also control the flows of the orders, both incoming or outgoing. But of course, it has also to be said that this is something which can be regarded also as a downside, because the more direct the communication is, the faster the communication itself is. So, of course, passing through the central authorities can mean some disadvantages in terms of the speed of the procedures. So this is something which is to be taken into account in order to finalize the work on the draft legislative decree, which is intended to go through very, very soon. So today we have this communication assisted by the Minister of Justice, but we had also, of course, and I guess we will have also a specific relation in the afternoon, the fundamental cooperation and work carried out by Eurojust in order also mainly to assist and to facilitate the transmission of active certificates from Italy to foreign member countries. And more generally talking, when it comes to the assistance to be provided for the judicial authorities, apart from the contribution provided for by Eurojust and by the Minister of Justice, we have also to focus to underline the fundamental work which the law enforcement agencies, of course, make every day in order to facilitate every single procedures. And we have also a precise legal framework regarding all these activities carried out by all these Italian public institutions, which are the circular issued by Eurojust on 2nd December 2000, the Ministry of Internal Affairs circular issued on 12th January 2001, and also the circular issued by the Minister of Justice, the Italian Minister of Justice, on 18th February 2021, of course, 2020, 2021, and last 18th February 2021. At this point, I don't know if Anna Maria can show the other participants the statistics I transmitted.
Absolutely. Yes.
Okay. As you will be seeing in a moment, they regard both passive case and active cases.
Are you able to do?
Not to share the screen, but I can also, like, of course, I can.
No, okay. I will.
Scusate, devo autorizzare io il dottor Fini, perdonate, provvedo.
I can also read them out, so it's more or less.
Amalia, autorizzi me che casomai lo condivido.
Yes, however, now Mr. Fini can share his desktop and sì, Professor Mangiari.
But I can have them offline, so I can read them out, so okay. the participants will have a complete overview on the statistics data collected. We can notice that, and this comes mainly from the comparison between data referring to 2021 and 2022, that there is a significant increase on the cases. This is applicable when it comes to both passive cases and certificate cases. And namely, we received 34 freezing confiscation in 2021, while it is actually the other way up. So 15 passive certificates in 2021, 34 in 2022 from all different states. I would say that as regards the freezing certificates received in 2022, the major number of them comes from France and Germany. We have to say that most of them, the major part of them, have been recognized and executed and enforced. We have evidence of just one out of them not recognized and not enforced, but it is due to the fact that at the time of the execution of the request, the bank account was empty, so the certificate had actually been recognized, but it couldn't be enforced due to the lack, to the absence of money on the pertinent and on the relevant bank account. Then, and anticipating somehow what we'll be saying about challenges, we have a very high number of certificates which at this moment, at this stage, result as pending. As you can see, in 2022, we have even more of them, but I guess this is also because there are plenty more certificates received. Anyway, I wanted to stress out, we have been talking about this also with Anna Maria. This is also statistics data that, according to the mandatory provisions of the regulation, we had to send in to send to the European Commission. We have to say that not all of them, namely the 19 certificates resulting from the second slide, the second statistic scheme, are presumably really pending. One of the challenge which has to be highlighted is that not always, and not really always in a timely manner, we receive a feedback from our judicial authority, which normally give execution to the passive certificates only, also without giving us, or anyway without giving us in real time a specific communication. So that means that sometimes the real pending cases can be even less than one set out in this scheme. This is a challenge on which, of course, we can do something, but there is at the moment no other means instead of the one of calling on every single judicial authorities and ask for a specific feedback. So it anyway means an extra additional activity, which is not always possible to carry out. And of course, this can, as I anticipated before, this can be even more relevant in case the direct communication channel will be finally sorted out and adopted as a solution when finally the legislative decree will go through. We have also, on the other hand, statistical data regarding the active cases. So the certificates. Okay, last thing about the passive cases is about the crime involved. I've seen that when, as you can see, the state involved, the one said France, mainly involved France, Germany, and Portugal. And when it comes to crimes, this is a general value. I mean that we can refer to both 2021 and 2022. The crimes for which the certificate are normally issued mainly reception of stolen goods, fake money laundering, but also conspiracy and other crimes as corruption, fraud against the European Union, and some other few cases also with other crimes. When it comes to active cases, we have here even more up-to-date data referring to 2021 and 2022 and 2023, just the first 6 months. The first months, actually, I would say the first 9 months, because the statistics thereof is very up to date. And so we received so far 79, almost 80. Well, we issued, sorry, almost 80 freezing certificate, and almost 20 confiscation certificates. When it comes to the states, again, the more involved states are Lithuania, Germany, Spain, and Belgium, but also a wide number of other member states are involved, as Lithuania, as Romania, Austria, Slovakia, Svezia, Luxembourg, Poland, Croatia, Greece, Bulgaria, Slovenia, Portugal, Malta, and also France. Talking about the type of confiscation and freezing coming into issue when it comes to active cases, we have to underline that the most of them are preventative seizure, so freezing relating to money, which is to be intended, which is meant to be the profit of the crime. Sometimes also by equivalent, I mean the same sum of money having the same value of the good, which is the good used to commit the crime, or which is the profit of the crime. But there is also a specific category of confiscation, which can be regarded as one of the main relevant when it comes to active confiscation certificate, which is the work of art. We have got a specific provision in our law on the cultural heritage, which is Article 174, and which allows for the confiscation also when upon dismissing of the procedures by the judge for criminal investigation, and which is normally done with on the basis of grounds recalling other orders or other judicial acts, which can be, and we will see this, a challenge when it comes to the application of our regulation at the issue. Anyway, this kind of confiscation, of course, relates to crimes which are the crimes normally involved when it comes to cultural heritage. So, for example, receiving of a stolen good, but also peculation and also other crimes, similar crimes. So we will be talking. We have been talking about some challenges related to this last type of confiscation, and I guess this is maybe the first challenge we have to talk about in this part of the intervention. When it comes to challenges, we will see that they can be either general or particular. They can depend on the way the regulation is applied or is implemented in single member states, but they can also somehow be implicit or anyway a kind of almost inevitable consequence of the regulation itself. So we will be distinguishing, we will be telling the one from the others. Talking about the first one, as I already said, this is a very specific one, and it relates to the kind of confiscation I've been talking earlier, the confiscation of work of arts, according to Article 174 of our Law 42 of 2004. What are the challenges when it comes to this kind of confiscation? First of all, the issue of the bona fide thirds. It is possible according to Article 19, paragraph 1, letter E of the regulation, that there can be the grounds to make the decision, the confiscation decision, applicable also to those persons, as far as there is no element which shows off their participation in the crime. But there is also another challenge, which is more related to the certificate itself. And as I said, normally the confiscation order contained in the dismissal decision for the lapse of time. This is really something which happens on a regular basis when it comes to this kind of proceedings, because they take a lot. So the crime are not very serious. So what it can be that I hear some echoes. I don't know if there is some specific issue. Yeah. So this is something very common in this field, because the investigation normally take a lot. The crimes are not that serious in terms of the penalty. So also the regime for the lapse of time provides for not a very long term. So it can happen that the crime is extincted due to a lapse of time, but still there is the interest of the state to recover the work of art, which is undoubtedly the profit of the crime. So basically, normally the grounds set out in the decision, the confiscation decision, are normally the one recalled in other orders and in other acts, and this can be a real problem when it comes to the application of the regulation, and this is because of the provision contained in Article 19 of the regulation, paragraph 1, letter C, or even letter H, which deal with I could say the fair trial, maybe in this case the fair proceedings needs, because the rules I've been talking about refer to the incorrect or anyway lacking filling in of the certificate, or even more specifically to the needs of the fair proceedings. So the right to actual judicial remedy, and also to an impartial judge and to the defense lawyer.
Sorry, Mr. Fini. Sorry, Mr. Fini, if I interrupt you. There is someone who has the microphone opened. Can you close it?
Yes,
so
I
that,
said it, but, yeah.
Okay, sorry.
Oh, very, very kind of you. Very kind of you. Yeah, so the mostly Article 19, paragraph 1, letter E, can be crucial in order to identify the challenges related to this kind of confiscation and to the certificate thereof. Sometimes the motivation, the grounds for the confiscation, which are in the confiscation order contained in the dismissal decision, are not sufficiently clear or anyway complete, because the confiscation order recalls other acts, and this can be a problem when it comes to the issuance of the certificate. This is also because, as we will see when talking about the general challenges, while the general use is that only the certificate has to be sent, there is a specific provision as regards both freezing and confiscation order, calling for the issuing authority, at the request of the executing authority, to send in also the orders on the basis of which the certificate have been issued. And this is even a most significant challenge and criticalities, which is also the other provisions still regarding to both confiscation and freezing and confiscation. calling actually the provision, as we will see, calls for only, even in this case, in those cases, for the translation of the certificate. But we have to say that in the practice, this is something which is not true, because mostly the executing authority calls also for the translation of the order on the basis of which the certificate has been issued, apart from the certificate itself. So this is to say that when it comes to this important active case, I mean the confiscation relating to work of art, and mostly when it comes to crime already statute barred, we have got this specific challenge. General challenges to be highlighted are, on the other hand, the uncertainties on the tool applicable, and also on the competent authorities. At this regard, as a member of the European Judicial Network, I can say that a great value help can come from EJN, and this is applicable. This is true with regard to both the direct communication with the national member correspondence, but also only by accessing the website, which is very, very modern and which is of great value to all the practitioners, and which beyond all the other tools contains the Atlas, which is a fundamental website tool giving important information to all the practitioners on the competent judicial authorities in all member states with regards to all European Union instruments, mostly the one based on a mutual recognition and mutual trust, like the one we are talking about now. Still talking about the general challenges, we have to, of course, to focus on something I've already anticipated, is the insufficient, incomplete, or anyway incorrect filling out of the certificate. Now maybe we can focus on the incorrectness due to the absence of a proper identification or location of the good at issue, as well as a proper description of the facts, the merit of the case, but also the grounds on the basis of which the measure, both freezing or confiscation, has been adopted. In the practice, we are actually also dealing with the judicial authorities involved, but also during our the cases assisted along with Eurojust, we realized that there is a really easy, I would say, solution, but anyway, it can be helping out a lot. Best practice, which is the one which consists in before the issuance of the same certificate, to carry out every possible activity aimed to gather any possible elements in order to properly identify and locate the good at issue. And this is not just by talking with each other, but also by issuing the proper other, and this is something which actually happens in the practice sometimes, the proper extra European instruments, European Union instruments. I'm talking about EIO, of course, when it is applicable, but also rogatory letters when the first one is not applicable for different reasons, or for the state or for the object of the request. But also, in the most important cases and the most difficult cases, the way forward could be the setting up of a JIT, helping out, as I said, in identifying properly the good or any way to locate it in order to address the competent judicial authorities with a proper request and with a request, a correct request referring to the good, which is actually the profit of the crime, for example, which anyway has to be phrased for the needs of the domestic criminal proceedings. Still talking about the general challenges, there is also maybe the more general one. I've already been saying something about it, which is the challenges relating to the translation of the certificates, but also, as I said, in the practice of the orders on the basis of which the certificate, either freezing or confiscation certificate, has been issued. We got a very two general rules, one for the confiscation, the freezing order, the other one for confiscation order, which are the Article 6, Para 2 and Article 17, Para 2 of the regulation, which provide for only the certificate to be translated, so not the order on the basis of which the certificates have been issued. And this is also, of course, the general rule with regard to the transmission itself, apart from the translation. As I said, normally the transmission of the certificate is enough, but we have also got two provisions, one for freezing orders, freezing certificate, freezing, generally talking, and confiscation, and the other one for the confiscation, namely Article 4, Para 2, and Article 14, Para 2, which provide for the possibility for the state to ask for the transmission, as I already said, of the orders on the basis of which the certificate has been issued. And as I said, in this case, even though there is a specific provision setting out that in these cases also the translation of the orders of the state orders would not be necessary, we can say that in the practice, most of this is, of course, when Italy comes at issue as an issue state, but I have to say also sometimes when Italy comes into issue as an executing state, most of sometimes judicial authorities, anyway, the central authorities call for the translation of the order themselves to be sent. And this is a challenge with which of course derives not from the regulation itself, but the but from the way the regulation is applied in every single member states.
Okay, I suppose
let me please, Anna Maria.
Yeah. I suppose that is enough, or have you?
Oh, just a couple words about a couple of general situations, but really in 1 minute. Still a general challenge relating to the incorrect filling of the certificate is that not always the obligation to consult each other between judicial authorities is obeyed, is fulfilled. While this is, of course, set out in Article 8 and 19, Para 2 for both freezing or confiscation. And this is something which can be worked on, because the provision set for this basic assistance, reciprocal assistance between judicial authorities, and which can be very, very useful in order to overcome difficulties which can be only partial and which can, of course, be solved through this consultation. And the consultation in this case could be either through judicial authorities, but also through central authorities, and also through police cooperation channels like the different areas offices, but also the dedicated networks, the dedicated existing networks like CARIN and STAR initiative. Yeah, this is the more relevant challenges we have identified so far. Of course, just in case you want, I've got also some other comments on more specific situations, but I leave the floor to you, and of course I remain at your disposal for any clarification you may need. Thanks a lot for the attention.
Thank you so much for this so rich speech and explanation of the Italian situation. I am sure that there are many questions for you. Ernesto? We are not able to hear.
Okay, good morning, everybody. I don't have many questions. Really, it is difficult for me to understand who is doing what to whom and for which kind of crime, because in looking to the data provided, things have been put together. What we are trying to prepare with Matteo, it's a table, and I hope Mr. Fini could fill the table with the data available, where they systematize country demanding and the crime involved, the answer, at least in order to have a quite complete view, also with the different countries. This will be very good, and I think probably only the Minister of Justice could provide and systematize all this data together. For the two tables which has been provided, things are different between one and the other, and it will be very nice to have the same data from the other countries, of course, but the main question is the following. Why so few data? Also, if there is an increase between 21 and 22, and which is really does not explain what are the main difficulties. I think someone has the microphone open still, and there is a lot of noise. Sorry, which comes back to me. And why so few data are in Italy when we are trying to freeze and confiscate a lot of assets in Italy? Looking into this data, the conclusion is that crime is only at Italian level and not abroad, when we know that people are investing abroad a lot of money and assets. So looking to this data, the comment is very tough, because we are putting things in the finger of one hand.
Michele, would you like to answer?
I think I didn't get the question actually, but anyway, generally talking about the data, I have to say preliminarily that the tables are different because the first one is the official one. We are being called on to provide to the Commission on the basis of the regulation itself, and which regards only the passive cases. And as I also explained to Anna Maria, the second one is a bit different, and it's like kind of consolidated data, also taking into consideration the need and the reservation needs connected to Italian proceedings still ongoing. So there is, of course, also due to the not really high number of cases, pending cases, the need not to communicate too much when it comes to proceedings like those one which are normally still ongoing. But anyway, from the tables, I can say that at least I am able to connect the data to every single member states. mainly talking about the passive cases table. We have got also all the data also gathered not only according to the state, but also according to the state of the procedures, and so to the outcome of the procedures. In some cases, the not given outcome, because the procedures are still to be regarded as pending. So of course, the first table, which is the one also we are called on to send to the Commission, is more complete. But as I said, this is the only one we are obliged to send to the Commission, even because every single state has the same obligation, and at the end the Commission put everything together, and they can have also a full picture of the situation. About the question the professor answered, I didn't get. I mean, he's been saying that.
No problem.
Please.
Sorry, Mr. Fini, if I interrupt you. So there is an authority in the Commission who is collecting data, as I understand from you. So
of course, European Commission.
But who in the European Commission is collecting this data? This is the Commission. But the Commission in general, DG Justice, DG Home, who?
Is the competent service of the Commission. Of course, we have got the we send our statistics throughout our agency in Brussels. So then the Commission receives the data, and they know who actually deal with them. So when it comes to the question, the crime, of course, are committed everywhere in Italy, but and this is when of course passive certificate come into issue, but also outside, and this is of course when active certificate come into issue. So maybe I didn't get properly the question Professor Savona answered. So if you can be so kind to say it again, maybe I can be able to reply to it.
Yeah, my answer was a comment. So few data about seizure and confiscation in proportion to the same data at a national level, which means the comment is that crime looks to be only at a national level and not at international level, when we know that many people are investing outside. So in terms of power of freezing and confiscation of the criminal proceeds, there are a lot of difficulties at the moment in doing these. But this could be solved once we can look to the data coming from the Commission, covering 27 countries altogether. This was my understanding. Can we request to the representative of the Italian Minister of Justice in Brussels to approach the Commission and to see at which level are they collecting data for the 27 countries? This will be extremely important for the projects, not only in Italy, because it looks from you that somebody in the Commission is collecting data, and we know that in the regulation there is a mandate for providing data, as you are doing correctly to the Commission. But it is difficult to reach the authority who is doing this collection.
No, it's not difficult at all. I mean, it is a dedicated service of the Commission. I can also by myself seek it and give you, of course, an outcome in a very short time. So it's not difficult at all. As you said, it's a mandatory, but it is something very common also with regard to the other European Union instruments. We carry out surveys and statistics on the basis also of the other judicial European Union instruments, and namely about European arrest warrants. We fill out every single year a survey which refer to incoming cases, outgoing cases, procedural European arrest warrant, executive European arrest warrant, state-related data, crime-related data. So it's something very common, and normally the service of the Commission is the one having competence in the relevant field. So in this case, I think the one also dealing with issues related to crimes and to asset recovery issues.
Well, if you could be our ambassador of the project,
Yeah,
this would be a fantastic achievement, because at the moment I've been asking to Eurojust and nothing comes from them. So I think there is a difficulty in the Commission to provide data, but this will be extraordinary.
Yeah, I mean, it won't be a big deal to come up with the service of the Commission. The issue maybe can be, the underlying issues can be to have all this data, those data available. Of course, it's something which does not is not on the end of the Minister of Justice, Italian Minister of Justice. I don't know if the Commission, for some kind of policy, does not make public available all the data, or maybe they don't do it for some time. So this is a different issue, of course. But I can, of course, tell you and all the other participants which service the Commission is dealing with all this stuff. Yeah,
this would be fantastic.
Of course.
Okay, but other question by the other colleagues, by other countries? So in the end, the feeling is that Italy, until now, Italy has not met particular problems with the implementation of preventive confiscation order as preventive measure, non-conviction based confiscation, or I have not correctly understood. I speak about active case. Yeah? When we ask.
Yeah, when it comes to this kind of confiscation, of course, active cases confiscation, we can say that we did not receive any specific evidence on this, but I guess, of course, there has to be challenges related to the different way to perceive this kind, and also to recognize this kind of confiscation. That, as you all, of course, already know, Italy is a bit forward compared to the other countries in the use and application of this kind of confiscation. Non-conviction based confiscation is a general accepted confiscation in our system, and this is not applicable to every single state. So we know also that there are different ways to intend them. Sometimes there are kind of administrative procedure, civil procedure, the so-called civil forfeiture of other system, mainly common law system. We have to say, and this comes also from my experience in other working group, that there is an increasing sensibility to this kind of instruments throughout all the Europe, and mostly among certain countries, apart from those who which have already implemented this kind of confiscation. There are a few of them, but not just a few, but every day more of them, which are anxious to learn about the system and want to implement them also in their system, because they they eventually understood it's the best way to fight against crime. We say that the fight on the personal level is not enough. The aggression of the illicit goods is fundamental, and when it comes to the aggression of illicit goods, also the preventative measures, the non-conviction based confiscation, are very, very valuable. So what happens also in the other context is that we normally explain how our system works. We set out that it's not like a police system. It's not a proper administrative context. It's still a criminal context. We can talk about criminal proceedings, but we can definitely talk about proceedings in criminal matters. We have got prosecutor and judges involved in the procedures.
Okay. No, I would like only to understand if until now we have a case of refusal in order to implement this kind of this model of confiscation.
Not a big evidence. I mean, not for themselves, because they are definitely, as far as we know, they are normally intended to be covered by the regulation, and so the issues can relate, of course, to other aspects involved in the actual cases, even when relating to a non-conviction based confiscation. We do not have evidence of specific issues arose for the nature of the confiscation itself. Of course, I have to underline here that this is, and this is even more true for the active cases, something which we can do on the basis on the only data we received. We have said that sometimes, and most of the times, we do not receive in a timely manner all the data. So we will, of course, we need also other sources to make this assertion more general. And
thank you so much. Okay,
if I may,
please.
I'm sorry. Thanks, Professor. I would have, I think, two questions for Mr. Fini, whom I thank a lot for the presentation. The first one would be just stressing the point that Professor Savona made about the disaggregation by crime of data. If you could provide just some information about that, meaning in your data, you showed the number of requests for or by many countries, and you listed the many crimes that are related to. And the question would be then, which are the crimes that are related to each request? That I think would really help us just framing the subject, understanding a bit how the instrument is applied. And the second question would be, do the prosecutors put you in copy when they send an order, a confiscation order or a freezing order? Meaning, is the ministry always involved in each procedure, or there is just a communication at the end of the year or each month on the cases that are done, and how we could improve the communication of data by the prosecutors, in your opinion? Thanks.
Yeah, I think actually I've already said that when it comes to the communication, normally it isn't complete. We, of course, as regards the active cases, receive information of the issuance either directly or from Eurojust, which according to the memorandum of understanding is competent to receive also these certificates and to facilitate and assist in their execution. So I guess we will have some solutions in order to improve the communication also from the legislative decree intended to be approved soon. We will see. Of course, we have also to understand that the instrument is relatively new. We have to consider that the European Arrest Warrant framework decision is 2002, and the other one on transfer of sentenced people is 2008. So this is really a new instrument. So we need sometimes to fully implement and it and to adapt our, and I'm talking about every member country's legislation, internal domestic legislation to it. For example, it would be easier also to gather as the time goes. As we go along, it will be easier also to gather data, because it will be fully in a fully electronic way. But we have also to consider that the challenges the judicial authorities offices on the field experience every single day, because they are not provided with full electronic databases. So it's not that easy when it comes to research which have to be done manually to gather all the data you are asking for. And we are not asked also to provide by the regulation itself, because as I said, the Commission calls for the passive data only. When it comes as regards the crimes, the tables are very general, because more or less they reflect the trend with regard to mainly the most of the states involved. I mean, as I already said, most of crimes are frauds, money laundering, and the general trend regarding all the certificate issue refers also to the different member states involved. So we didn't notice so far, and I guess also with regard to active certificate, the data can be, will be, the available data will be more and more accurate as we go along, but we didn't notice any particular difference with regard to the crimes when it comes to the different member states involved. In this case, the receiving member states with Italy as an issuing state. And the crimes are, as I said, also in the same order in which they are, they compare in the tables, the one set out in the tables themselves.
Okay.
Thanks.
There is another question by Anna Sakellakari. Anna, please.
Can you hear me?
Yes.
Perfect. Hi, thank you. I will just put a short question, because I'm checking here the article of the regulation asking for the statistics, and I was asking myself in the tabella that you saw us before, it was not mentioned the average period that you need for the execution of the confiscation and freezing orders. So it's something that you don't have the data, or it's something that you just missed in the like sending to the having to send still to the commission, or the prosecutors did not send you the data? Basically are 2 points: if there are cases for compensation and restitution for the victims, and if you have data for the average period that the prosecutions need for the execution of the freezing and confiscation orders.
Yeah, maybe I haven't been enough clear. This is not the table we have sent to the Commission, because that is an official table, and I don't think we are authorized to send the same one. Of course, this is also because we are talking here about these recent proceedings. Of course, we will be available to send out also in this context the more public available information, so we can also add some other data if applicable in the coming days. But taking into consideration what I have already said about the challenges due to the incomplete transmission of data from the judicial authority offices, we do have information, the information you've been talking about, so also about the compensation, but still you have to consider that normally this is the last phase of the proceedings, so it can be also that it is not communicated to us because we received of course the communication of the first phases, but at some point maybe the judicial authorities do their job without giving us any notice. But we do have no information about some cases of compensation. We do have also examples of decision on restitutions to goods to the victims. even of course also of course at the request of the sending state, the issuing state. So we received also really in a couple of cases the decision of Italian judicial authorities calling for the restitution to the victim of the frozen or confiscated goods. And this is of course what we communicate to the Commission on the basis of the provision you have been you recalled. I want also to repeat that the tables in this context have to be jotted down, also taking into account the needs of the domestic internal criminal proceedings, and of course with all the rules ruling and providing for the necessary confidentiality of the data, of some data at least. So this is why, with regard also to a limited number of cases and to ongoing proceedings, some data at the moment can be communicated from us in a full way.
Okay, thank you so much to Dr. Fini. And now I give the floor to the representative Dr. Ileva of the General Prosecutor Office for Bulgaria. Please.
Hello, can you hear me?
Yes.
Okay. I have a presentation prepared, so I'll try to share it for everybody. Just a second, because I'm not sure how to make it. Is it possible to see the presentation or not?
No, Mrs. Leva, you should change the page because we see your desktop with the list of the documents, but not the presentation itself. So you should change the page to be shared.
Okay, I'll try again.
Right.
You have to open the documents before.
Before sharing.
Before to share.
Okay, it's open.
Okay, now you have to try to share. Okay, perfect.
Oh, now it's okay? Perfect. Maybe just go to the beginning of the presentation. Okay. So the presentation and the issues in there are based on some of the answers we got from our colleagues from the prosecutor's office mainly. We disseminated the questionnaire to judges and prosecutors, and for the final report, we rely on very much on the answers of from the judges, because as you will see, they are they have the main role in implementing and working with the EU instruments regarding freezing and confiscation. And I hope that we've got these answers soon and prepare more complete report than I can give you now. So the presentation is mainly from the point of view of the prosecutor's office. It should be noted that Bulgaria has experience in implementing regulation 1805, as well as other instruments on mutual recognition of freezing and confiscation orders, mainly as an executing country. This is inferred from the statistical data we have for 2021, but this is an issue that I will analyze at the end of the presentation. The statistical data, they are still in process of collecting, and we hope that we can present them in the final report by the end of October. And this is the place to mention that regarding our legislation, the authority that should collect data on implementing the regulation is the National Statistical Institute, and not the prosecutor's office or the Ministry of Justice. So we rely on this authority very much. They know that they should collect the most the data with a lot of details about countries and goods and so on, but we will receive the data later, I suppose. Before pointing out some of the problems encountered in the practice of the Bulgarian judicial authorities, I think it's necessary to present in general the manner in which the regulation is implemented in Bulgaria as an issuing and executing state. At the time of the entry into force the regulation, two separate laws for the recognition of orders of competent judicial authorities of other states were already effective in Bulgaria, one in relation to freezing orders and the other in relation to effective confiscation orders, freezing orders, and other financial sanctions. The implementation of the regulation has been carried out by the Bulgarian legislator by amending these two laws. The first one, the Recognition, Execution, Issuance and Transmission of Property Freezing Orders Act. Shortly, I will refer it to as Freezing Orders Act. And the second one, the Recognition, Execution, Issuance and so on. It's a very long title. It's concerning about orders of confiscation. So, and briefly, I will refer it to as a Confiscation Orders Act. So you can see that we have two different laws, one regarding freezing orders and one regarding confiscation orders. And this is the manner that the Bulgarian legislation decided to act when we're talking about admission of judicial decisions issued by states of the European Union. According to the practice of the Bulgarian courts, this is an information from my colleagues from the prosecutor's office, the order for direct confiscation of property is most often applied. They say that it is extremely rare, if ever, to have a freezing order or confiscation order of equivalent value against third parties, extended confiscation or non-judicial confiscation. The types of criminal offenses that most often are met into the coming in Bulgaria certificates. The most common of them are fraud, tax crimes, and human and drug trafficking. This is mainly when a Bulgarian citizen or somebody with connection to Bulgaria has been convicted in another country, and the other authority has found out that that person has any property in Bulgaria, and these are most common cases when such certificate is coming to be executed in Bulgaria. The types of assets that have been subject to confiscation are diverse. Most often it's a matter of movable property, money in the bank accounts, most often. In many cases, the holder of the bank accounts is a legal person whose manager has been sentenced of a tax crime, entering into fictitious transactions and tax evasion in the same time. Of course, we have a lot of cases with immovable property, mainly apartments or houses or other real estate. In order to identify the property to be frozen off or confiscated, preliminary investigations are carried out, including the use of European investigation order. There are numerous examples of cases in which, based on received European investigation orders, the Bulgarian prosecutors have identified assets through the registry agency. In Bulgaria, this is the agency which has data about real estates all over Bulgaria, and through banking and credit institutions. It should be specified that for the purpose of obtaining information about balances in bank accounts by the investigating authorities in Bulgaria, a court decision is required in every specific case. The requesting state is provided then with this information, and consequently a certificate containing a request for confiscation of immovable property or movable located within the territory of Bulgaria and owned by the guilty person is received. Talking about the competent authorities in Bulgaria, for the issuance of a freezing certificate pursuant to Article 2, Para 8 of the regulation, it is the court of first instance. The proceeding about the issuance of a freezing certificate, the proceeding is being initiated on the grounds of a request from the prosecutor. So the prosecutor in practice locates the goods that should be freezed, and then files such a motion to the court of first instance. The freezing order is then transmitted by the prosecutor for execution directly to the competent authority. The freezing order and the certificate directed to the competent authority in the executing state. And when it comes, this is when it comes to the pre-trial phase. When it comes to the trial phase, the order is transmitted by the Bulgarian court to the competent authority of the executing state. For execution of freezing certificate, pursuant to Article 2, the competent authority in Bulgaria under Freezing Orders Act, which refers to the Civil Procedure Code, it is the bailiff. In every district city in Bulgaria, there is a bailiff office, which the bailiff office to the government, and this is where the freezing certificate, when the court says that it should be executed, receives the freezing order to make the proper actions. For the issuance of a confiscation certificate, pursuant to Article 2, Para 8 of the regulation, the Confiscation Orders Act says that it is the court of first instance. For the execution of confiscation certificate, when the court says that it should be executed in our country, here the role is has a National Revenue Agency. This competence is based on Article 3 and so on of the National Revenue Agency Act, according to which the agency executes orders for confiscation or forfeiture of property and decisions imposing financial sanctions issued in a member state of the European Union and recognized and enforceable in the Republic of Bulgaria. This is the legal basis for their actions. When it comes to refusals, in Bulgaria there are cases of refusal to recognize for execution, confiscation or forfeiture orders of foreign countries. The most frequent grounds for refusals are the act for which the person has been sentenced and confiscation of property is requested does not constitute a criminal offense under our legislation. Another reason is that no evidence has been gathered to deny the claims of the person whose property is confiscated that he or she has not been notified of the criminal proceedings against him or her. In the meantime, this is a third kind of reason, the property has been disposed of for which a confiscation certificate has been received and another person, legal or natural, is already its owner. Of course, the third reason is not in the frames of the grounds of refusal regarding the grounds of refusal, which the regulation says, but our court sometimes thinks that this is the only way to finish the case. The court says that certificate may be admitted to be executed in Bulgaria or be refused to be executed in Bulgaria. It should be noted that there are cases of incompleteness of the received certificates from the issuing state, and they are removed by consultations with the relevant authority. So no cases have been reported by my colleagues in which the recognition and acceptance for execution of a foreign authority's order for property confiscation or freezing to have been refused because the certificate is not presented, is incomplete, or clearly does not comply with the order enclosed. If there are such cases, the court is going to ask the issuing country to enclose more documents or to clear out some issues, and then to decide if the freezing or confiscation order should be executed in Bulgaria. When we are talking about difficulties in implementing regulation, again, I should mention that we rely on very much on the judges and their practice, but unfortunately we do not have any answers from them. So maybe the difficulties and the proposals furthermore will not have this will not be the same that as I'm saying today, because some amendments, I hope, we should make in the national report by the end of October. It should be clarified that the problems do not refer only to the implementation of the regulation, but to all orders of seizure of confiscation issued by foreign authorities and sent for recognition, execution in Bulgaria during the last years. As I mentioned, the measures to implement the regulation are amended in two separate laws, which exist more longer before the regulation is in place. So sometimes when I talk to my colleagues, tell me do you see any problems with the regulation? They talk to me. They are sharing problems, not exactly with the regulation, but with admission and execution of orders received based on other EU instruments. So the problems are most commonly in as an executing country in identifying the competent court. I will stop on this point later, just to mark them. Secondly, the translation of the certificates or the orders to be applied. Thirdly, in identifying the assets to be confiscated. Then delay on the procedure when the certificates are not accompanied by the confiscation order. And then problems related to guaranteeing the right to effective legal remedies. Impossibility to fulfill orders, multiple orders for the same person or assets. Let's go in some details regarding some of the marked problems. As an executing country, significant problem is to determine the competent court that would examine the proceedings under the Confiscation Orders Act. Usually the court of Bulgaria, which is the only competent authority for the issuance of a property freezing order and to admit a freezing and confiscation order issued in another country, sometimes the district courts argue each other because, for example, the real estate which the foreign country wants to be freezed or confiscated are located in two different cities. For example, if the defendant has an apartment in Varna near the sea, and an apartment in Plovdiv, for example, then the district courts of Plovdiv and Varna began a dispute which of them is competent to admit this order and, of course, then to execute it. As you can guess, the argument is not I am competent, no, I am competent, but every time the court tries to send the case to the other, and sometimes this procedure takes a lot of time. When the competent court is not sure that it is competent for the case, it refers to Eurojust for assistance if a consultance with the issuing authority is needed. The Ministry of Justice is rarely involved. As to my knowledge, in some cases the information is comprehensive, but in other cases it is not. Of course, because at the end of the day the court decision should be issued, those problems are solved, but sometimes they took a lot of time. Another issue is difficulties due to the quality of the translation of the certificates. In some cases, the translation is inaccurate and incomprehensible. Yes, for example, it cannot be established from the translated text whether the request is to freeze property in a pending criminal proceeding or to recognize and execute a final decision of confiscation, or it concerns confiscation that has been ordered in civil proceedings, because if it is so, these orders are not subject to recognition and execution under Confiscation Orders Act, the law which is in place in Bulgaria. Of course, a correspondence is the way to resolve these problems. Regarding translation, difficulties arise also due to the absence, incompleteness, and/or insufficient quality of the translation of the certificate. This is the quality, and/or the interpretation of the text when the translation is not precise in terms of the legal terminology used. In such cases, the Sofia City Court assigns the translation to a translator from a specialist who is proficient in legal terminology, and that is why the problem is solved in many cases. When the translation is made by the executing state, in our case the Bulgarian court, no reimbursement of expenses is required from the issuing state. According to, I mentioned here the article of the Confiscation Orders Act, the costs are borne by Bulgaria. Of course, in cases when the costs are large and excessive, pursuant to paragraph 2, the Bulgarian court may propose to the issuing state to share the expenses, but as far as I know, rare cases are solved at that way. The court in Bulgaria, as an executing authority, often has to demand from the issuing authority to submit the property freezing, the freezing or confiscation order. So a lot of times the confiscation, the certificate comes to Bulgaria without the order, which is the base of the issuing of the certificate. For this purpose, the Bulgarian court gives the issuing state a reasonable time to prepare the translation and deliver the documents to the Bulgarian court. Again, when we are talking about the communication, usually it's carried out through Eurojust and rarely through Ministry of Justice. Based on the type of seized or frozen assets, the main problems are related to, again, to determine the competent court. I already give you an example. More problems arise from the actions of the persons, natural or legal persons, because when they know that such a certificate or an order is issued, they move their address where they live or where the company is situated, which makes another district court to be competent, and of course this delays the process very much. So difficulties arise when the legal persons whose properties or bank accounts balances are to be confiscated, they change the company seat by register at addresses in different district cities. Pursuant to Article 44 of the Criminal Procedure Code, jurisdiction disputes between courts. This is the case that I mentioned, that courts are arguing between each other who is competent to admit and to obtain the order to be executed in Bulgaria. The disputes are decided and resolved by the Supreme Court of Cassation, and this process also delays very much and delays the process and creates time for disposal or concealment of the property, which is subject to confiscation or serves as collateral. Another problem regarding connected with the type of the assets arise when the goods which are subject of a confiscate order are at the same time secured under Article 72 of the Criminal Procedural Code in pending criminal proceeding conducted within the territory of Bulgaria. Of course, pursuant to the Confiscation Orders Act, the court of the executing state may postpone the execution of the confiscation decision when it could prejudice pending criminal proceeding. But the problem is that the court is the authority who has to decide whether to admit the order to be executed in Bulgaria or not. And the prosecutor's office is the authority which knows about pending criminal proceedings and related and freezing orders related to them. The problem, according to my colleagues, is that there is no mechanism for interaction or to communicate between the court and the prosecutor's office regarding the exchange of information, and there is no institution which is obliged ex officio to follow the criminal proceedings that are completed or pending within the territory of Bulgaria. And this is a factual and legal obstacle to the admission of the confiscation and a reason to postpone the decision. Maybe this problem should be solved as the prosecutor who is obliged to take part in the case of admitting confiscation or freezing order in the court should, before giving a statement whether to be admitted or not, should obtain some information whether this property is freezed in connection with another criminal proceeding in Bulgaria, but I'm not sure which is the way to be sure about that. This is one of the problems my colleagues shared to me. And if the court knows about the pending criminal proceeding in Bulgaria, which in connection with which the goods are freezed, the court may postpone the execution of the foreign freezing or confiscation order, but it is not also regulated whether a postponement of the decision can be continued and rendered the second time under the same request, or whether new proceedings, so a new certificate should be sent from the foreign country to the court in Bulgaria, and how the expiration of the limitation period for the execution of the confiscation being under the Bulgarian legislation, because we have some period after when it expires, the Bulgarian authorities do not have right to take any actions regarding this these goods or this movable and immovable property. Another problem is related to the responsibility for managing the immovable or movable property that is subject to confiscation. Article 24 from the Freezing Order Act states that it's managed and guarded in accordance with the Counter-Corruption and Unlawfully Acquired Assets Forfeiture Act. So the authority responsible for the management of this property are formally the directors of the territorial directorates and the inspectors thereto, according to Article 16 of this Act. but this is a very, how can I say it, very common rule, and they are responsible for a lot of freezing goods, not only for those who are freezed or to be confiscated from foreign countries, but to all goods which are a subject of freezing, seizing, and confiscation according in connection to every national criminal procedure. So there is no procedure for the appointment of a responsible official for the property until its actual handover to the foreign authority, who would manage the property and protect it from encroachments. So any actions which would destroy or anything else the good which should be confiscated further. The problems arising from translation, not always. According to my colleagues, the information contained in the freezing or confiscation certificate is complete, clear, and accurate. This is largely due to the difference in the legislation of the different member states, as well to translation problems and legal issues connected to it. Difficulties mainly arise in relation to the description of the criminal offense, for which recognition and execution of the judicial act is requested. Difficulties arise when assessing whether there is double criminality or whether the criminal act falls within the scope of Article 3 of the regulation. Respectively, here is mentioned the article of the Confiscation Orders Act, which says the same as the Article 3 of the regulation. Incompleteness is also found in the specification of additional circumstances. In some of the certificates, it's not specified whether the limitation period for execution of the confiscation or freezing order, according to the legislation of the issuing state, and whether measures have been taken for its execution, so that it could be assessed whether the limitation period for execution has also expired according to our legislation. Data are not provided to a sufficient extent whether the judicial order or confiscation order has been issued in absentia proceedings, whether the accused person, respectively the defendant or the affected person, has been provided with the legal assistance, and whether he or she has been personally aware of the ongoing criminal proceedings and the possibility to appeal against them. These arise problems when the defendant has not been personally notified and informed, and then such argument is brought to the court, who must admit to execution the confiscation order. Proposals for changing and supplementing the model of the freezing and confiscation certificates. I think that furthermore we should obtain more opinions on that issue. So far, it is proposed to fill in the certificate more data on the limitation period for execution according to the legislation of the issuing state, whether measures of execution have been taken, what kind of measures, of course, as well as what measures have been taken exactly by the relevant authorities of the executing of the issuing state, I suppose. Proposal for changes in the national legislation with a view to ensuring better implementation. I think that one of the proposals should be to introduce a strict order for the management of the property subject to confiscation. Secondly, to provide for possibility to reopening criminal proceedings when the prerequisites of the criminal procedural code are met. Here I should explain something which is important according to me and my colleagues. We already have one case when a court in I don't know, one of the district courts in Bulgaria had refused to admit a foreign freezing order to execute it in Bulgaria because some documents were missing, and the court put this decision. The prosecutors found out some procedural circumstances which in a normal case would allow to ask the Supreme Court in Bulgaria to reopen this case. The problem is that it turned out that this kind of decisions, court decisions, which are based on the Confiscation Orders Act and are based on foreign confiscation orders, are not a subject to reopening, even if, as I put here some extraction of Article 422 of the Criminal Procedural Code, even if somebody, a judge or an attorney or so on, have disguised some circumstances which were important to the final decisions, and even if some substantial violations of the procedure were in place, even in those cases, those kind of decisions are not a subject of reopening, and this is something which is a legislation problem, and this is one of our proposals, this to be amended. Regarding statistics, as I mentioned, the National Statistical Institute now is in process of collecting statistics, not because they don't have the numbers, but because the numbers do not present the whole picture. So I hope that could be done later. For the purposes of the previous national report, we received some certain information from the National Statistical Institute, but it is regarding 2021. As you can see, they inform us that outgoing freezing requests are 3 during this year. You can see that there are no incoming freezing requests during this year. Furthermore, about confiscation, there are a lot more than freezing orders. The confiscation orders received in Bulgaria for recognition and execution, which are admitted for execution, are 59. And the incoming requests which are rejected for execution, are 81. This is the numbers that the Statistical Institute gave to us. But here I would like to mention something. I would mention the fact and then to analyze it the way the way I see the problem. When I asked the prosecutor's office, are there any freezing orders, because the freezing orders are normally issued during a pending criminal proceeding, are there freezing orders sent to other countries or received from other countries to the prosecutor's office? I received the answer that there is one incoming certificate and freezing order, which has been denied and rejected for execution by a Bulgarian court. Of course, this is something bad, and I ask my colleague, please give me the documents to explain our partners in the recovery project why there are a lot of rejections, and the only one incoming freezing orders has been rejected. My colleague sent it to me, and it turns out that actually, it was a European investigation order accompanied by a court decision from Spain, which were sent to prosecutor's office, and the decision, the court decision, was the court the court decides to issue a European investigation order, and this is sent to Bulgaria. But my colleague, instead of taking the actions that the investigation order requests, he filed the whole documentation to the court and asks for its recognition in Bulgaria. Of course, the court says, firstly, I don't have a certificate for freezing any freezing order. Secondly, I don't have freezing order, so I should refuse admission of something that I don't have. This is a very interesting case, in my opinion, because it shows, firstly, that behind the numbers there is not always strictly a certificate and freezing or confiscation order based on the regulation 1805, and secondly, that we should make some actions not only with legislation amendments, but with trainings, a lot of trainings, because in my opinion, this case shows that sometimes prosecutors and sometimes judges, as my colleagues shared to me, need more education about the EU instruments, the implementation of how to work with the regulation, and the two laws that I mentioned, Confiscation Orders Act and Freezing Orders Act. Okay, the number of the freezing and confiscation orders includes all received for execution in Bulgaria and sent from Bulgaria in 2021, without specifying whether they are based on the regulation or some other instrument, EU instrument. So this is more information about the special laws that I mentioned once or twice. The first of them have been in force in 2007, and the other one in 2010. So the manner to implement the regulation by our legislator was to amend these two laws. So thank you for your attention. If I may answer the questions, I'm ready to.
Thank you so much. It is a real clear survey of the situation in Bulgaria. My feeling is that there is a kind of no real mutual trust in Bulgarian in relation to the foreign authorities, because you have spoken about refusal in consideration of the type of seized and frozen assets, of the type of confiscation order. Also you said no that maybe there is a problem of training, no? The feeling after your speech is that it is not real clear that the regulation is a mandatory instrument that has to be applied for each model of confiscation, freezing confiscation order, and that normally if there is no a violation of a fundamental rights, it is not possible, no, to refute the implementation. So it is my, I would like to ask you if it is also your feeling, you know, that in Bulgarian maybe it is necessary, it is training, you know, in order to inform, or maybe also to enforce the mutual trust and the knowledge of the other system of law and so on. And another question is that it is not clear for me, sorry, why you propose, you or you know, after your research, you propose to the reform of the national system of law in the aspect to give the opportunity to reopen the proceeding. It is not clear the connection with the implementation of the regulation. Okay, for now, and after maybe other question. Also, Michael Kickling. Michael, would you like to ask?
Yes, thank you very much, and thank you for this interesting presentation. It gave really a good insight into the everyday practical problems, yeah, that arise, yeah, and that are very different in the various jurisdictions. I have one question, or maybe even more a remark to the interesting statistics that you have presented. So we have seen that requests for 59 confiscation orders were admitted, and the value is only 65,000 euros. That means on average about 1,100 euros per case. Yeah? Isn't that a good sign that mostly pity cases are targeted by these instruments? Yeah? So obviously there is no big case, no big mafia case or organized crime case amongst these. Is there an explanation maybe for that?
Okay. Other question? Okay. Tanya, maybe.
Okay.
Yes.
I would like to have the whole picture and to present to you, but I'm afraid that at that moment it's not possible for me. Yes, I would share the opinion of Professor Mogheri that maybe there is not a clear understanding of the regulation and in implementation of EU instruments, because I mentioned that when I'm asking my colleagues or I'm not ready to answer for the court, but when I'm asking the prosecutors, do you have any problems with the regulation and implementing it, they became sending and presenting me cases from 2014 or 2010 or so on. And when I ask, but I'm talking about the regulation, they stop for a moment and says, but I'm not sure whether the freezing order or the confiscation order was based on the regulation. These are common problems for every case, and we do not focus so much on what is the basis of receiving that order. Of course, again, I should say that we didn't receive yet the opinion of the court, and maybe the picture would be more difficult. But yes, Professor Muggeri, I cannot deny this inference, because I have the same. And I'm not afraid to present it in front of you. Why reopening the cases? Maybe because this is extraordinary and not always applied way to revoke and to obtain a different court decision, but sometimes, and it happens in not so rare cases, when we have a decision of the first instance court, and it is appealed in front of the appeal court, and the appealed court decision is final. So when the court or the judge is not so familiar with the regulation and other EU instruments in that field, and sometimes it makes a decision, he make a decision which is not the correct one, and which is not only the correct one, but he issues a decision which is not in line of the legislation in Bulgaria and the EU instruments. So in these cases, a lot of criminal proceedings and related to them will be reopened by the Supreme Court of Cassation, but it turned out that it is not possible for the specific decisions related to admission of confiscation, issuing and freezing orders issued by foreign countries based on the regulation and based on the Confiscation Orders Act. This is something that, of course, turned out when the court decision was found out by my colleagues that during the procedure the judge breaches the rulings that the law obliges him to follow. If you allow me, I would prepare the case which is the basis of my analysis and my presentation, and I can present it to you. It was very long as a circumstances and as a detail, so I decided not to present this in front of the partners in the project, but I can do it later.
Maybe also for the next workshop in Milan in the afternoon, because in that case, in that meeting, we have to speak about hard case, no? Or maybe if it is a complex case, we can speak about this case. Okay.
Okay. Actually, I can mention only one detail. It was the one court, the district court denies to execute the freezing order because there were not documents which should be accompanied the certificate. And when the requesting country, which I think was Italy, later sent another certificate about the same goods and accompanied with the proper documents, the second court, the district court in another city, find out that the issue has been already analyzed in front of the court and finds that this is not bis in idem problem and refuses to issue an order to issue a decision about admitting or not the certificate. So this is a clear case when reopening the case would be very useful, but according to our legislation, as I mentioned, is not possible. So the third the third question about the value of the goods which were subject of the confiscation orders, I cannot tell you anything more because I received the numbers from the National Statistical Institute, and they received them from the Supreme Judicial Council, and the Supreme Judicial Council received the numbers and the value from every district court in the country. So the way of the information is very difficult, stoned, and I cannot answer at the moment anything more, but I will write down this question and hope to be possible to give you more details for later.
Okay. Are there other questions? No.
Professor, yeah, I'm here.
Yeah.
Yes. Thank you. Thank you very much for the presentation, first of all. You highlighted as a practical problem, obstacle in the procedure, both executing and especially passive procedure in Bulgaria, the negative jurisdictional conflict between your domestic judicial authorities. Could you please tell something more about not details, but like concrete examples of this negative jurisdictional conflict that can happen in your system and how it lengthens the time of the procedure and it delays the outcome, and in this way factually obstacles the achievement of the goal of the regulation on the mutual recognition and execution of confiscation orders. If this, what was interesting to me is like to know some concrete examples about, for example, goods or properties when there are doubts where are located, or some examples to be more clear. Thank you very much.
Thank you. I mentioned something during my presentation, but for example, when freezing or confiscation order comes to Bulgaria, the dispute is between the court where the district court where the person where the person lives as an official address, and the court where the property which should be confiscated is situated. This is one of the basis for a dispute. Another one is where the confiscation is confiscation is regarding two different real estates. So one located in, I don't know, in capital Sofia, and the other one is located in another district of Bulgaria, and of course another district court. This is a basis for receiving, maybe the Sofia district court receives the certificate and the confiscation order. The court says, oh, but there is an apartment in Varna, so I'm writing a decision, maybe in, I hope in 3 days time, and sends the file, the whole case there in Varna, and the court in Varna says, I hope in 3 days, but the other real estate is in Sofia. So I think that the Supreme Court of Cassation should resolve the dispute, because this is the authority, and sends back the file in Sofia, but to the Supreme District Court, which, as I'm familiar to their work, within a week it may issue a decision about which of the district courts is competent to solve the case, and this, as you see, may delay the process 2 weeks, I think, and you know that sometimes every day is essential.
Thank you very much, Ms. Ilieva. And yes, this is what I meant also with the question, that it can hamper the good result and the success of the request. Thank you.
Professor, you're on mute. We can't hear you.
La sentiamo, professore.
Sì. Sorry. Sorry. Okay. I think that it's better to do a brief break of 15 minutes, and after we can start again with Germany. Okay? So about 11:45. Okay? 15 minutes of break for a coffee. Thank you so much, Dr. Ilea. Your speech was real rich and clear, really focused on the problem. So thank you so much. Okay, see you later in 15 minutes. I am here. Okay. Okay. Okay, we can start again. I give the floor to Anna Sakellakari for the report for Germany. Thank you so much, Anna.
Thank you, Professor Malzeri. I will share the screen. Let's see if will everything work out. Okay, so now theoretically you have to see the presentation. Is it everything working well? Because I cannot see you.
No, we can't see.
No.
It's just a black screen.
Yes. Only black.
Okay.
Black situation.
We'll try again. Because we were working with the Zoom, so now we have to. Okay. Presentation works. Is it now working?
No, Anna.
No.
Still black screen.
Okay, instead, Amalia, maybe we can do it like that, that you can share and I could do
Yes,
a
of course.
presentation.
Of
That's
course.
really kind. Thank you. Sorry for the
Moment,
inconvenience.
Find out your presentation.
I'm sharing. Okay. After all the COVID and all the things with the digital situation, however, still we have problems. So I will just start maybe saying some making some remarks for our report, because unfortunately, thank you so much, Amalia. Now you have to see everything, I think.
Sorry, you can see the presentation?
I'm saying it correct.
Okay.
Correctly.
Okay, perfect.
So hi to everybody. We are I'm now like responsible to present for the German situation, but I'm afraid this would be the introduction that such a great practical insight as we heard before from the Bulgarian report maybe we won't have today, because we are still expecting some statistical data till theoretically it should have been done till the end of September, but we are expecting it maybe for October. If we don't have them from the official agency that I will explain you after, we maybe have to do some interviews from the ARROs, the German ARROs, or find the contact person from the Ministry of Justice in order to get this statistical data. But I will try to present you the case as it is right now. So Amalia, you can pass to the first slide. These are the 5 points of the presentation. So I will present you first that I found out in a new report from Europol that I found it really interesting for some the number of the annually sized assets in the EU. After the second would be the competent authorities for incoming and outgoing requests in Germany to clarify a bit the scenery. Third point would be the German statistical data, but here with the remark that I will present you the case of the national situation and not of the recognition, because the thing it was that the latest statistic after our request to the Ministry of Justice, we had the new statistic for the reporting year 2022, but it does not have any does not mention anything about the regulation or about the requests. So here we have a problem with official statistics in Germany, and we hope that probably maybe through the interviews we will cover this gap. But the official statistic for the reporting year 2022, that it was published on August 2023, so this August, was not mentioning anything about the recognition and the number of the freezing and confiscation orders. 4 would be the difficulties encountered in the practice, but this would be according to a case from the Commission that we have a study from 2021, and it's also mentioning Germany. And 5, it would be the good practices. And in the written presentation, I will send you also an annex with the legislation in Germany, so that for the practitioners it would be easier to follow in English, which is the legal situation in Germany. So let's start from the 1. New statistical data from Europol. According to a new Europol report published this September in 2023, based on an ad hoc data collection from 24 member states, the value of assets seized annually in the EU has almost doubled to at least 4.1 billion on average, and this is for the years 2020-2021. Compared to the previous estimate made in 2016, there we had a really common report that everyone was mentioning, the Europol report from 2016, when we were asking for statistical data, and at that time it was 2.4 billion on average for the years 2010-2014. So what is also mentioned, it was that in particular cash was the most commonly seized item, followed by bank accounts and vehicles, and less frequent categories of assets seized include shares, gold, other movable property, including vessels and virtual assets. So this report also emphasizes that although there is still a lack of fully reliable data on illicit proceeds generated by serious and organized crime in the EU, an overall conclusion may, however, be that the large majority of illicit proceeds remain in the hands of organized crime, so the conclusion that it's not new to us. It is said, and this is important, that the annual revenues of organized crime in the EU ranges from 92 to 188 billion, and this shows exactly how small the percentage of illicit assets seized in the EU still is, and this is at around 4.4 or 2.2 of the total illicit revenues. And especially from the organized crime, it remains like less than 2% of the annual proceeds from organized crime. This was just an introduction in order to show to all of us that it's still a lot of work to be done. And let's pass to the situation in Germany, which are the competent authorities for incoming and outgoing requests. So in Germany, the legal basis for the mutual recognition on freezing and confiscation orders, namely the provisions implementing the regulation 2018 in German law, is in the articles 96a at sec of the IRG, we are calling it. It's the Act of International Mutual Assistance in Criminal Matters, so it's kind of a codex. We don't. It's a law, Gesetz über die internationale Rechtshilfe in Strafsachen. You will see it as IRG. This is the common name. So, pursuant to the first article, 96b(11) IRG, the competent authority for the recognition and execution now of the incoming foreign freezing orders is the local court. We are calling it Amtsgericht in Germany. So, if in case we have a simultaneous transmission of freezing order and confiscation order, the competent authority will be the one for the confiscation order, as I will tell you afterwards. So, deciding on the recognition and execution of both will be the regional court, this time the Landgericht. So I just looked after the two presentations before, which will be the local jurisdiction, and this you can find it in the article 51 of the IRG, and it's the court, mainly is the court in whose district the property to which the confiscation relates is located, but there are, of course, also some other cases if the assets cannot be found there, but you can you will find everything in the annex of the legislation, the German legislation. So the competent authority now for the recognition and execution of incoming foreign confiscation orders is, as we said, according to 96b(2) IRG, the regional court of the articles 51 and 51, IRG, the Landgericht. And mainly this regional court decides first on the admissibility, and in the second step, it's also responsible to decide on the grounds of refusal. This it's contrary to what was previously the case in the context of the implementation of the Framework Decision 2006 in the German legal system, because at that time also the prosecution could allege these grounds for refusal. Now it's just the court, the regional court. The regional court if we speak about the confiscation orders, and the local court if we speak about the freezing orders. So now, pursuant to Article 96b3 ERG, the Public Prosecution Office, the Staatsanwaltschaft, of the articles that you are seeing in the presentation, is competent to receive the incoming freezing and confiscation order and to prepare the relevant decision to forward it after to the court. We are speaking for the decision on recognition and execution of the orders. So this is mainly the scene, which are the authorities responsible for the incoming requests. Now it's also interesting that we have an explicit mention to the right to be heard and the right to legal aid, that they are mentioned in Articles 96b4 and 96b5. And now on the question, what is happening with the foreign freezing of the recognition and execution of foreign freezing and confiscation orders, just to put it simple, we have the Public Prosecution Office responsible for the execution and enforcement. So we have to say that to understand that the prosecution mainly receives the case, it's preparing the decision for the court, and it's also responsible for the execution and enforcement of the decision. And this is mentioned in 96C1 ERG. So it's acting mainly the prosecution as an executing authority in the same way as for the execution for a German confiscation order. So the latter, the prosecution may also postpone the execution of a freezing or confiscation order or consider it also impossible. And the legal remedy available to the person against whom the freezing or confiscation order has been issued is according to 96D1 ERG, the immediate complaint. In German is sofortige Beschwerde. So this is the legal remedy. And now I will just mention which is the competent authority for the outgoing requests. So for the recognition and execution of German freezing or confiscation orders to another member state of the EU is according to Article 96E1 ERG, the Public Prosecution Office, which is responsible for both issuing and transmitting such requests. There is a special ruling that you will find in the presentation after about the regulatory offenses, but I won't mention it now because it's not that important, I think. And also just to mention that the right to the legal aid is the same article for the outgoing as for the ingoing request. So here we have also an application, and is explicitly mentioned the right to legal aid for the persons concerned. So now let's pass to the German statistical data and to the main problem that I already mentioned to you. This is the online site that you can find the information that we have, the latest from this August, but for the reporting year 2022. There was, as I said, no reference to the mutual recognition and execution of confiscation or freezing orders. So this situation that I will present you now is what is happening mainly in Germany inside. So just some remarks after reading and understanding the statistics is first that there is a gradual increase in the total number of the autonomous confiscation cases throughout Germany. So we see that we have numbers like 592 for 2022. This we understand that it's not the case, as I said, for the mutual recognition, because we saw in the previous reports we have around 20 cases or 15 cases. So this number is just inside Germany. And this is for the years to 2020, 2022. Another remark is that interestingly in the year 2022, if we see from a number of 100,000 persons against whom an asset recovery measure is to be enforced, almost half of them will be subject to asset confiscation or asset value confiscation measures. So from all the asset recovery measures, half of them would be asset confiscation or asset value confiscation measures. In Germany still. The number, third remark, the number of executed freezing orders almost doubled in 6 years between 2017 and 2022. You can see that the freezing orders executed in Germany, they are 16,544 for 2022. And there are two main observations for the confiscation orders inside Germany. First, the number of the executed confiscation orders more than tripled this time between 2017 and 2022. And second, it is clear that here the number of the executed confiscation orders is always much higher than the number of the freezing orders over the reporting years. So we see that mainly, let's make the last remark and I will tell you the summary. So we have also that the estimated total value of confiscated assets in Germany appears to increase significantly from only, let's see now, for example, 2017, we have 198, around 198,000 euros to 922,000 euros in 2022. So we see that we have really a great increase for the estimated total value of the confiscated assets. And we speak always, as I said, for inside Germany. This is the situation, and we see that this makes us think that probably something is happening with the new legislation in Germany that we presented in the last conference. So the prosecutors and the courts are getting more familiar with the whole situation with freezing and confiscation. But we have no idea what is happening for the moment with the recognition. The idea is, as I said, to contact the agency that is the Bundesamt für Justiz. You will see it in the next slide. That it's basically it's where we are taking the statistics, the official statistics, but maybe to get in contact with the director of the mutual legal assistance agency, or to contact the AROS, or as a third solution to get in contact with the, we are calling it Oberstaatsanwälte. These are the prosecutors, the general prosecutors of each federal state in Germany, because we have the federal system. So this is the third option in case we don't manage to find any data from the other two possibilities. So now let's pass to the difficulties encountered in practice. As you see in the slide, here we could present you a list of challenges as highlighted in a secondary source, namely a Commission's report from 2021. And this includes also Germany among the other member states. And you will find the link, of course, in the written presentation. So there are difficulties. First, in the cooperation was mentioned between the FIUs of other member states or third countries, first. Second, there are some concerns about the reliability of data provided by the public prosecution offices to these relevant statistical offices. Here is, as I told you before, in Germany, the Federal Office of Justice, Bundesamt für Justiz, the competent authority collecting such statistical data in this area. This is an agency, but the department is the Ministry of Justice, and this is just an agency responsible for the statistical data in this case. Third, there is no central register for some assets, such as real estate and boats, yachts and pleasure boats in Germany. And real estate is mainly organized by property and not by the name of the owner. So it is mentioned that it's not easy to find out who owns basically the property. Another point, another difficulty is that there is really a lot of time taking to respond, that there is the use of problem with the use of confidential information, the duration of the freezing, and the completeness of the information provided. But as I said, unfortunately, there we cannot provide you like such an insight as we have in the last report from Bulgaria. So now the AROS, another point of difficulty is that the AROS lack a central register and staff. And just that you have an idea what is happening in Germany, there are two AROS. we have the BKA police arrow and the judicial arrow. So the judicial arrow is the contact point for the mutual legal assistance in criminal matters in general, and the judicial arrow receives requests from third countries and forwards them to the relevant prosecution offices and vice versa. Both collect basically statistical data. This is why we hope that maybe there we can get something. And since 2000, the police arrow collects basically annually data on tracing, identification, and freezing of assets. And the judicial arrow is responsible for collecting data only on freezing and confiscation of assets. Another problem mentioned in this report is the lack of evidence on the beneficiaries of criminal assets. And last point is that there are difficulties, as it was mentioned before, also in Bulgarian report, in the management of the assets, exactly, especially when they need a special treatment to maintain their value, and more problems in the establishment of asset management offices and official channels for the cooperation international and European level. And it's also mentioned, as we know, that often prosecution offices in charge of asset management and disposal do not have the relevant specialization. So this is in order to say what we mentioned also before, that training is also something really important. And now, just in order not to say the bad things, the good practices that they were mentioned in this report, there were 4. That the Federal Criminal Police Office, the BKA, and State Police, Landespolizei personnel has really specialized in, at least in financial investigations. The Federal Financial Supervisory Authority, that is the so-called BaFin, the database is really good and has information on holders and beneficiaries of bank accounts, car holders, immovable property with real estate registers and company registers. So there is where the prosecutors could really work with. And this Federal Criminal Police Office, the BKA intranet, is mentioned that it has an internal Wikipedia, kind of Wikipedia on asset recovery. So there they have tips and best practices on asset recovery that they are probably they are just not public, but they are kind of having inside the agency, inside the police. And last, it was a Bavarian pilot program that outsourced management of frozen assets to a private company. So this was mentioned as also a good practice, because probably we have a good results from the management, I suppose, but there we can still make an interview with somebody, a prosecutor from there, in order to tell us more. So this was basically the presentation, really short, and I hope we have more infos for the end of October for the written part. And if you have any ideas, because I saw that Michael Kilkling is also with us, whom to contact to get this data, if not from the official statistical data, we will be really happy to hear it. Thank you so much, and you can, of course, pose any question.
Okay, thank you so much, Anna, for your presentation. Do you have some information about cases of refusal in the implementation of a confiscation order without conviction in Germany?
No, the only things we have in the statistics is they are not mentioned at all, grounds for refusal or such a thing. So the only way we can get these things, it's directly from the prosecution offices that they dealt with this thing. Or we have, of course, in the academia, all the written, but it's just the fears, what could happen, I mean, as grounds for refusal. So it's not something from the practice. So really applicated cases, or like in the statistics, it's not mentioned. It's not mentioned.
Okay, so it can be very useful to send some by computer. The new question that Matteo and Pietro prepared for prosecutor, no? In order to try to better understand which is the real situation in Germany. In the report of Bulgarian, this element appear, so this information appear. So in this case, this can be real useful. But in the end, the trend is positive, no? Because there is a real increase of the case, no? Of mutual recognition in Germany, in any case. Another important problem that arise from this presentation is the problem of the management of the assets in this praxis of the mutual recognition. No? We will focus on these problems in another step of our project, but this can be a real problem, no, for the mutual, for the cooperation, mutual recognition. No? Because, for example, in Italy we have a specific legislation about the management of assets, or also in firms, corporation, but maybe in other countries there is not this specific legislation about the management. And so this is a problem to face to increase the cooperation and mutual recognition. But in any case, in the end, Anna, the trend is positive. No? This is my impression.
Exactly, it's also how I'm reading the statistics. And yes, from 2017 with the new legislation in Germany till now, we see that it's really increasing. And also for the autonomous confiscation orders, that it's these non-conviction based confiscation also included. So yeah, would be interesting to see what is happening. But it's also somehow I mean, in the official contact that we had with this Bundesamt für Justiz, they answered to us that in the new statistic from this August, we will have the data for the regulation. And we asked again now to send how it's missing again, because I mean, they are the people that they are receiving basically from all the prosecution offices, central prosecution offices from the federal states. And I suppose that they are the ones who have to send them to the commission. Because in this atlas that I checked now in the European Judicial Network, it's this the central authority. So I suppose that they are the one who have to send everything in the commission. So if they don't have them in the official statistics, it's a great problem for Germany. But let's wait until 1 month to see to find out what is happening with the direct contact to the prosecutors in order to understand.
Okay. Yeah, there is also the problem how are organized these statistics. Maybe one of our proposal for the future can be try to organize, try to gather the important information in a kind of software, no, in order to facilitate the preparation of the statistic. To have all the relevant information, which kind of assets, which kind of confiscation order, which kind of crime, and so we can have a better survey of the situation. There is another question by Joao Conde Correa. Joao, please.
Yes, good morning. Can you hear me? Can you hear me?
Yeah, okay. Yes.
Yes. So good morning. Thank you for giving me this opportunity, and thank you, Anna, for your wonderful presentation. If I understood correctly, and correct me if I'm wrong, there are more confiscation orders than freezing orders. Normally, is the opposite. So how is that possible? Do you have an explanation? Thank you.
This is a really good question. probably I would say that I don't have an answer directly, but I'm guessing that like the freezing orders have also a lot of now from the academia perspective, but they have more constitutional problems. I mean, there are the confiscation orders in Germany. Somehow the landscape is now clear, but for the freezing orders, there is still a bit of whole discussion how long they will take. That everything is probably unconstitutional after. So maybe the prosecutors are not feeling still safe to go for the freezing orders. The question is, if you don't have the freezing orders, how you arrive to the confiscation orders? I mean, probably they confiscate directly with the fear of leaving the assets, of losing the assets in the meanwhile. I don't know. I don't have any insight from the practice. But this is a good point to ask them, and I will note it down. But yes, I suppose that it's a problem because they don't feel safe still with the freezing orders. At least in the academia, it's a whole debate still at that point.
Probably the confiscation is a final order with more safeguards. So the approach of the German authorities is that it is better to wait for the final order if they find the assets without freezing order. But maybe it is the explanation. Okay, are there other questions? Yes. No. Okay. Okay. So now the next is in our program. Sorry. Okay. Lithuania General Prosecutor Office. I give the floor to Jūratė Radicauskienė. Thank you so much. Please.
Yes, good afternoon for everyone. Thank you for a great opportunity to talk to you and to present our situation. I prepared presentation, so I'll try to share my screen. Can you see my presentation?
No.
No?
No.
No? Yes. And now?
No? Amalia,
No.
maybe you are able
Yes,
to
I can
override.
do. Yes, I can do. Just a minute.
Okay.
Okay.
Yes. Nice. So first of all, preparing this presentation, I would like to present the data on which this presentation is based. The data is from Prosecutor General's Office of Lithuania, because we have our information system and we collect statistical data, and what regards confiscation orders. During this project, I applied to National Courts Administration, and they gave me some statistical data based on their information system. So what regards Lithuania about freezing and confiscation orders, about what regards legislation, So CPC of Lithuania has provision regarding this, and these provisions give direct link to other law on mutual recognition and enforcement of decisions of EU member states in criminal cases. So this is the main law what regards freezing and confiscation orders. And now I would like to provide you statistical data regarding of outgoing freezing orders. As I mentioned, this data is collected within our office, and I provided statistical data for 2 years. Because this regulation came into force by the end of 2020. And what is also important, we started to collect statistical data, full statistical data from 2021. And I'll provide you for 2 years. We also collect data for 2023 as well, but this is not reasonable to provide because the annual year is not over, and we didn't want to have discrepancies into statistical data, because we annually provide data to European Commission, and 2 months are not finished, and we didn't want to have discrepancies. So we were able to specify also data of recognized and non-recognized freezing orders, incoming and outgoing. The reasons of this I'll tell you later. So next slide, please. So the next slide is in relation to incoming and outgoing freezing orders from 2021, and it is in relation to countries. So we see that mostly we received in 2021 from Spain, from Republic of Poland, from Greece, from Cyprus. Some 3 freezing orders were issued from Republic of Germany, and very little from Italy, Estonia, Netherlands, Hungary, and also Lithuania, as executed authority, executed 95 freezing orders, and many of them were issued by Germany, Belgium, Latvia, also Italy, Netherlands, and so on. Next slide, please. So in 2022, Lithuania, as issuing authority, issued 35 freezing orders, and most of them were issued to the Kingdom of Spain, to Germany, the rest of them to Latvia, Greece, Estonia, Belgium, Cyprus, Sweden, United Kingdom, and Ireland. And in 2022, Lithuania also executed 33 freezing orders from Germany, 25 from Latvia, from France, from Italy, from Poland, Denmark, and from other countries. So what is interesting about the crimes in relation to issuing of freezing order certificates? So main part takes economic and financial crimes in 2021, in 2022. As you see, 24 cases and 34 cases. Also, cyber crimes are very relevant. Also, drugs, not so relevant, but we had some cases. And what is important, mainly it is common bank account seizures. We didn't were able to specify data according the sort of property, but during interview it was cleared that the most common are bank account seizures. And now we go to the problems which Lithuania faces, and grounds for refusal applied in Lithuania. There were cases where competent judicial authorities of European Union still use the form set out in Council Decision 2003-577 on the execution of freezing orders against property or evidence in the European Union instead of regulations freezing certificate. And this was, there were the grounds to refuse of application of freezing order, and also freezing certificates were received without translation into Lithuania, even though the Republic of Lithuania has declared that it accepts only in Lithuanian language. What regards refusals to outgoing certificates from Lithuania, previously I mentioned that there were only 3 cases. We did not collect this data digitally, but I had interview of my colleague and asked what the problems were. So I was informed that one of the reasons were that when freezing order was issued, and finally it was clear that in bank account there were no assets, just 0 assets. And so this is it. And in some cases, other problems, they were not grounds for refusal. They were somehow sorted out during consultations. In some cases, freezing certificates were incompletely filed in. There were no relevant articles of the national law of the member states, not always included. Also, member states did not tick the boxes, even though it was clear about freezing certificates should have been ticked. And also there were cases where copies of national decisions were not attached to freezing certificates. And about Lithuanian competent authorities, competent authorities to issue freezing certificate is Prosecutor General's Office of the Republic of Lithuania, also Regional Prosecutor's Office of the Republic of Lithuania, and also European delegated prosecutor in the competence of the cases from European Prosecutor Office and Prosecutor General's Office and Regional Prosecutor's Office are issuing freezing orders and recognizing freezing orders according to the place of the assets. And what regards about competent authorities to issue confiscation certificates, so there are district courts of Republic of Lithuania, and it depends on the address of the residence of owners. If the residence address is unclear, so this is based on the territory of property place or the place where the main assets are. And now I'm going to statistics on confiscation orders. Lithuanian Prosecutor's Office is not competent in this field. And as I mentioned during this project, I applied to National Courts Administration, and they provided me data about incoming and outgoing confiscation orders. As you see, the main countries are Germany and Poland. Also Estonia and Finland. And also National Courts Administration provided information that all these confiscation mainly were made on monetary funds, and there were some value confiscation. I would like to note that National Courts Administration did not provide statistical data on other models of confiscation, about third parties confiscation, and so on. These are the data that we have, and this data we can disseminate. And confiscation certificates, crimes, so are smuggling, violation of road traffic rules in the influence of alcohol, trafficking in human beings, cyber fraud, theft, tax evasion, fraud, and money laundering. So this is it, and if you have questions, I'm ready to answer.
Thank you so much. One question is the ground for refusal the fact that the certificate is not translated in Lithuanian language? Is not possible to send a certificate in English language?
There were some exceptions in very urgent and very significant cases, but according to our law, we have provision to provide certificates in Lithuanian language. This information has been disseminated between EU members, and all EU members are informed about this.
Okay, this can be also one of the. This seems and also severe problem, no? serious problem. But in the praxis, no, there is this problem of the translation. It is, I suppose, for example, from Italy. In Italy, it is not so easy to find somebody who is able to translate in Lithuanian language, no? So maybe one of the rule for the future, or the in order to improve, no, the implementation can be also the rule that it is mandatory to accept a certificate in English language, for example, no, because maybe sometimes it can be very difficult, no, to find a good translator in technical language, in judicial language, no, and also the fact that the copy of the national order is not attached, no? It is in the regulation, this is not mandatory, no, to attach, but in the praxis, also in Italy, sometimes I heard this claim, no, that if you don't attach the national order, maybe the confiscation, the freezing order is not implemented in another country. Maybe it is important to clarify this, not for the implementation of the regulation. Maybe, but my question is, you said if the copy of the national order is not attached, but the copy has to be translated in Lithuanian language.
Yes, so when the copy was not attached, this was not a ground to not recognize. It's just I mentioned in other problems, but not as a ground for refusal. Just certificate must be translated.
Okay. Okay. Other question?
I will have one.
Please.
Thanks for your very interesting presentation. I would like to ask you one question related to the instruments that are used. You mentioned that also the Council decision of 2003 is used. We know also from our interviews that we are doing that, for example, an Hungarian authority has mentioned that they often use European investigation orders. And so my questions are two mainly. Are all the cases or the statistical data that you showed us due to the exact regulation of 2018, or are other tools used? And those are data that are on all the instruments, all the tools. And secondly, why are these other tools, these other, let's say, old tools used? Because they are, you know, well established, better established than the regulation, because people are not aware, law enforcement agents are not aware of the possibilities of using other instruments that may be more effective or not. So the question are all these cases within the regulation? And secondly, why don't we use always the regulation? What is the reason according to you? Thanks.
So this, I think the statistical data is collected in the frame of regulation, but I have to clarify it specifically because your question is so very, very specific, and I'm afraid to mistaken you, because I don't collect this data myself, and I have to ask my.
Thanks.
Okay. If are there other questions?
Yes, if I can.
Please.
Thank you, Jurate, for your presentation. I hope your name is all right. Looking into the numbers, the difference between incoming and outgoing requests is huge. I think we don't have enough data, but I think the same happens in Portugal. But what I want to ask you, is there any explanation for me in Portugal? I think it's lack of training. Is there any explanation in Lithuania for this huge difference?
Thank you for a very good question. Because participating in this project also it revealed this discrepancy, and we see, and I see one of the reasons could be that in Lithuania we have a very good searching tools for the property, because our officers have very nice tools, and it's really easy to find property in Lithuania, and other countries don't have such tools. So this might be one of the reasons, but other reason, I think we also should encourage our prosecutors, because I'm specialized prosecutor and I am also asset recovery officer from Lithuanian Prosecutor's Office, and I see also these numbers, and now we are thinking to do something to encourage our prosecutors, use more arrow channels, use more caring channels, and to improve our work. And I think this is the aim also of our project, to improve, to see discrepancies, and to go forward.
Yeah. Sure. Okay. Thank you so much also for these last suggestions for our project. And now I give the floor to Netherlands General Prosecutor Office, Jan Liesdeboer. Jan?
Yes, I'm online. Thank you. I will try to also share a presentation. I'm not sure if I will be successful. I don't see it in the options.
I can do if you want, Liz.
Yeah, maybe that would be quicker.
Yes.
Yes, thank you. For our presentation, we decided to focus on 2 points, some highlights from the statistics that we gathered, and the problems and solutions we came across in making our report. Naturally, in the report itself, all the questions will be answered. But we thought for this meeting, these 2 subjects will be the most relevant to pick out of the report. So to start with some statistics on the European freezing order, we see that we have around 90 cases incoming in 21 and 22. And they came from 18 different countries, and outgoing we have about 125 cases a year in these 2 years, and we have sent cases to 21 different member states. And then from the incoming cases, we see that the most cases we send to our neighboring countries, Belgium and Germany. And about 40% is to the other members, to the other 19 member states we also send cases to. And from outgoing cases, next to Belgium and Germany, Spain is a very important receiver for European freezing orders from the Netherlands. And that is because of that Spain is very popular with Dutch criminals as well. So we have a lot of cases for Spain as well. And the interesting part is that there are only 3 member states that we haven't had any cases with in the 21 and 22, and that is Greece, Slovakia, and I think Estonia. It was Estonia. So there are just 3 countries that we haven't had any case with in these 2 years. Then for the next slide, the type of crimes that are mentioned in these freezing orders when it comes to incoming cases. Swindling is mentioned a lot, money laundering, drug cases, fraud, and then other crimes. And from outgoing cases, we see that in the Netherlands, in many certificates cases, we also at least use the money laundering, and next to that, the swindling, the drugs, crimes, fraud, and forgery of documents is also are common crimes that are mentioned. And I should mention that when it comes to money laundering, in some of the cases we have a predictive crime as well, but in the Netherlands it's also possible to only prosecute for money laundering. So these certificates can be only based on money laundering as well. But naturally, in some cases you have more than one crime mentioned, and in other cases it might be just one crime. Then for the confiscation orders, incoming in 21, it was 29 cases. In 22, we see a large increase of numbers. It's 63 cases. They come from 7 different countries, and the most important countries that send cases to the Netherlands are Germany and Belgium. And Belgium is explicitly has started sending out a lot of cases in 2022. Now from the outgoing cases, we see that in 21 there were 12 cases sent. In 22 there were 10 cases sent. I should say that in prior years the numbers were a bit higher, but the central authority that is responsible for sending the cases is naturally depending on getting cases delivered to them to transfer. And in earlier years, most of the cases were sent to Germany and Belgium, but in the 2 years that are in these statistics, we see that Spain and Luxembourg are the important receivers at this moment. Then for the next slide, we see that these are the amounts that are covered by the confiscation orders that are executed in these 2 years. There were no statistics on the type of property or the type of assets in the execution phase, but these are the amounts that are executed. Then the next slide. For the crimes, then we see that it is also drugs, money laundering, swindling, fraud, also criminal organization, that are the most important crimes that are mentioned in the confiscation phase in the certificates. Then we have some slides on problems and solutions, and these are from our experience, the experience of our colleagues from the Central Authority for the confiscation cases, and from experience of the competent public prosecutors in the Netherlands. Maybe to remind you, Robert van der Ende and I are international legal advisors, and we assist public prosecutors in dealing with this regulation. So we come across with different problems they encounter when working with regulation. And one of the problems is really at the start of the process, and that is to have the up-to-date information assets. We often see that a certificate is sent or received for instance, a bank account, and then through the whole process of drafting the certificate, translating the certificate, sending it to the other country, they have to recognize it, they have to enforce it, and then at the end of the process, they see that there's no balance in the bank account. So it's really important that we have complete and actual information on the assets in the other member states to be as efficient as possible under these regulations, and also to use our limited resources well, and not spend time on cases that at the end of the day don't give any result. No, sorry, I'm still at a bit problem 1. So as a solution, we see that it would be useful that it would become more common to send an ARO request prior to sending a freezing order or a confiscation order, because many of the AROs in the member states already are able to at least give information on which bank accounts are still active in a member state. And in some countries, they are even able to give information on the balance of bank accounts, but that is an exception. In many cases, in many member states, it's only the information which bank accounts exist. And therefore, we see that it would be very valuable as well if AROs would be in all member states would get the competence to also check balances of bank accounts, to give this information prior to sending a confiscation order or a freezing order to another member state, and being more effective with the cases we do send across. So the next slide. Then the second problem we see in practice is that the time that is needed for drafting and sending and executing an order can be a problem in urgent cases. And naturally, it's just one part of the problem is that in many cases, colleagues from the law enforcement think about sending a request too late. So there will be an action day in 2 weeks, and then they see a bank account in, for instance, Lithuania, and they have the problem, oh, now we have to send an European freezing order. It also needs to be translated to Lithuanian, and we don't have that many translators for that language. So it takes a lot of time to be able to send that request, and then the time that the receiving country has to execute a freezing order when it's an urgent request, and especially when you want to execute it on a specific date, the time they have to act is really limited as well. So yes, we think that it would be useful if it would become possible to, at least in urgent cases, send requests in English. It would also maybe be a possibility to have specialized central authorities that are competent to deal with the urgent requests, so that you have the authority on the other side has experience in freezing assets or executing confiscation orders. And it would also be useful if in some cases it would be possible to, prior to sending the formal request, that member states have the possibility to perform an urgent freezing, an interim measure, so securing the assets, knowing that there is a freezing order coming. And in that context, it would also be very useful to come to European legislation on the possibility to have direct contact with exchanges for cryptocurrencies in other member states, to request them to soft freeze assets that are in wallets in exchanges in other member states prior to sending a European freezing order. So next slide. Then the third problem we identified was that in paragraph 1 of Article 7 of the regulation, it's mentioned that the receiving authority is able to perform all the necessary measures to execute the order that would be possible in a national situation as well. And we interpreted that our article of the regulation that if we receive a freezing order and the requesting authority says we need to freeze €500,000 euros, and they know there's maybe one bank account in the Netherlands, we can look if there are also other assets from the suspect in the Netherlands and identify them and then contact the issuing authority and saying, you sent a freezing order for just one bank account. We see other assets as well. Do you want us to freeze those assets too to be more effective in the execution? And especially under the regulation, the development that was made from the freezing the framework decision prior to the regulation. In the framework decision, you really need to identify specifically which assets in the other member state needed to be frozen and where they were. And in our opinion, and we checked with the European Commission, and they agreed that that was the intention of this article. The intention of the regulation is that you don't really need to be that specific. You need to have a reason to send the freezing order to the other member state. You need to know that there are assets, but if you don't know all the assets, it should be possible for the receiving authority to investigate the existence of probably other assets as well. So we think that it would be very useful if all member states would act in the same manner under this article of the regulation, also align their national law and their the way the competent authorities work together to be able to investigate whereabouts of assets, to trace all the assets of the suspecting member states, to even freeze more than is mentioned in the certificate when possible. Then the fourth problem. This was mentioned by other colleagues as well prior to our presentation, that the quality of certificates and the use of the correct certificates is sometimes a problem. So we too experience that sometimes we receive in the Netherlands certificates under the framework decision of 2003 for freezing orders, or under the framework decision of 2006 for confiscation orders. Naturally, the authorities that sending these cases are requested to send the correct certificate, and then the cases will be dealt with anyway. But it takes time, and it is a waste of time. That is, especially with freezing orders, is valuable time that is wasted in those cases. And then the quality of certificates is sometimes the information is not clear enough or not complete, and then you need to consult, and even also that takes time, and time is lost in being able to act quickly upon these requests. So we think one of the parts of the certificate for European freezing order that is especially difficult to fill out in our experience is part D, that is dealing with the assets, the type of assets and the type of if it's an amount of money or a specific property. And to translate that part of the certificate to the national situation of the country that is requesting to freeze assets, and then translate it to the national situation of the member state that is executing it, that is a difficult part, especially in our experience, because we have two different types of freezings. So if it's object-based freezing and you need to freeze a specific asset, it's a different way of freezing assets in the Netherlands than if you want to freeze assets for value-based confiscation. So especially in the execution in the Netherlands, it is for us very important to have really clear what type of confiscation is at hand in the other member states, so that we know how we need to act when we receive such a freezing order. So some adjustments maybe in the certificate would be valuable. But next to that, I think the things that are already mentioned before, education of practitioners is important, and it could be helpful to have a guide or a handbook for drafting certificates. We have one in the Netherlands for the Dutch situation to help Dutch colleagues how to fill out the forms. But probably these handbooks would be useful in all member states for practitioners how to correctly fill out the forms so that they can be dealt with more quickly in other member states. So the fifth problem is restitution of money to victims in cases where we have to freeze bank accounts. This is especially in the Netherlands a problem because when we freeze money in bank accounts, the money stays with the bank institutions, and the balance of the bank accounts is not transferred to the public prosecutor's service. So we need the cooperation of the banks when there is a request from the issuing member state to transfer the funds back to a victim, and that in practice is sometimes difficult. So we think that it would be good if there would be more harmonized regulations within the EU how to deal with those cases, which responsibility banks have to cooperate with these cases as well. The sixth one is connected to that, and that is the freezing of assets for victim compensation and restitution. The regulation has in Article 29 rules about restitution of assets that were frozen. But in practice, we see that sometimes issuing authorities are requesting to freeze just with the aim for restitution, and that is not the scope of the regulation. You need to freeze with the aim of confiscation, and then once it is frozen, it's possible to restitute assets to a victim. But in practice, we see that there is some need probably to just be able to freeze with the aim of restitution as well. If you don't really want to go for a confiscation procedure, but the only importance is that stolen goods are being returned to the victim. I think we should be able to cooperate within the EU as well. And then the second problem connected to this is the compensation of victims, which is not always concerning assets that are also proceeds of a crime. And in those cases, it is also under the regulation not possible to freeze assets, even though in the execution phase under Article 30, it's possible to say if once money is confiscated, it's possible if there is a decision from the national authority that a victim needs to be compensated, the revenues of the confiscation should be transferred to a victim. But the problem is in the earlier stage that we, I think in practice also need regulations under which we can request the freezing of assets for compensation of victims as well. So for us, we would see that it might be a solution to extend the scope of freezing orders under the regulation, although I know that this is a very complicated subject within the European Union. So I don't expect any quick fixes, but this is a topic that is really important in the Netherlands because we have a certain system for victim compensation, and we see this in practice that it's really complicated. So the seventh, I think this will be my last sheet. Or maybe not, I'm not sure. The problem is we also see that it would be good to improve the communication between competent authorities and understanding of each other. What we see is that if we send a request to another member state, we not always know where it is being dealt with, if it's being dealt with, what the result is. And if we receive information that it's being dealt with, sometimes we receive so much documents that it's difficult to find out from these documents what was actually done. So in this context, I think it would be a good idea to come with some standard forms that under the European investigation order there is at least a standard form for a confirmation of receipt, wherein also the contact details are included of the executing authority. I think that would be a very useful document under the regulation as well. And it would be probably also good to have a standard form for a decision on recognition or refusal, to know what is the decision that is taken in the other member state. And a very important form would be, in our experience, a standard form to communicate which assets are actually frozen and what is the estimated value of it. Because that is the thing you really want to know. Is there something frozen? Because in the further stages of the procedure of confiscation, the court needs to take a decision on those assets. So we really need to know which assets are frozen. And in execution phase, you also want to know that they are still there. So you need to be able to manage these assets as well. You need to know, are they frozen? Is there a time within we need to renew the information for the other member state that it knows that we're still proceeding with this case and we still want these assets to remain frozen. So it's really important for us to have this information and to have a better understanding of what is requested under the freezing order from the other member state. We also see that it is can be very important that prior to sending a freezing order, there is contact between the authorities so that you can discuss the case and explain what you want, and they can explain which information do they need from us to be able to execute it as good and quick as possible. So I think this would be very useful to have in practice. So this will be a surprise for me as well. Do I have another? Yeah, I have one other sheet. Then the securing of assets in the execution phase under the European confiscation order. Also, I will first explain the situation in the Netherlands is that there is a different authority within the Netherlands which is responsible for the execution of confiscation orders. That is the Ministry of Justice. And there is an agency under the Ministry of Justice that is in practice executing these orders. So it's not the public prosecution service that is responsible for this. And the public prosecutor is also not able to decide to freeze assets in the execution phase. So only prior to a court decision, the public prosecution service is able to freeze assets. Afterwards, it will be a bailiff in the execution phase that is responsible for freezing assets under the responsibility of the Ministry of Justice. So under the current legislation in the Netherlands, we are not able to send a freezing order in the execution phase of a confiscation order to another member state. But we see that in practice, if we send a confiscation order to another member state, the convicted person will be informed that this confiscation order is sent to that member state and that it will be recognized, and they are able to participate in the procedure of recognition. Then they're aware of this confiscation order will be executed in that member state, and they will make sure that they hide their assets and they won't be confiscated after recognition. So it is in some cases very important that you will be that you are able to freeze assets in the other member states prior to recognition of the confiscation order. Within the Netherlands, we can freeze assets without receiving a freezing order from another member state prior to recognition of a confiscation order. And this possibility is also mentioned in Article 18, paragraph 5 of the regulation, which is a very efficient way of cooperating because you don't need an extra form to send to the other member state, and there's not an extra recognition procedure needed to execute it. So I think that these two possibilities, if they would exist in all member states, they would be very useful. So for the Netherlands, we have a proposal for a new law in procedure where we're trying to implement the possibility to send freezing orders to other member states in the execution phase. But we would also want to inspire other member states to implement the possibility of freezing assets without the need to receive first a freezing order, just on the basis that they know that there will be an execution request for a confiscation order. So these I think are the problems and solutions we identified for this workshop.
much. And also for this clear approach, problem solution. So also for our research, this is very important, no? To offer some proposal of solution of the problem.
I see, maybe before you start, I see that Sandra Westra has raised her hand, and she's the Dutch expert from the Central Authority for the Confiscation Order. So maybe it's interesting to know what she has to say or add to my presentation.
Yeah, I would like to add, good afternoon, everyone. I would like to add one remark regarding the last solution to confiscate in the certificate, to make the request to confiscate before the recognition of your confiscation order. It's very important to have a recent ARO, because we cannot actively investigate if there is property before the recognition, but if there are if there is information, so a recent ARO, we can indeed freeze before the recognition of the confiscation order.
Thank you. Okay, there are some requests of question. Anna. Okay.
Yeah, hi, thank you so much for the elaborate presentation. I have just a question for this soft freezing or the additional freezing that you mentioned. So this kind of you mentioned that you can also like somehow say that I can freeze also more than the existing in the certificate, like just contacting the person, so just contacting the competent authority. So I was just asking myself at which stage really the affected person is informed, and if you didn't have any problems with the defense lawyers, because I think that these two things that you already mentioned, the soft freezing and the additional freezing, it's really triggering, I mean, for the defense of the affected person. So I'm afraid that if we pass such a legislation in Germany, it would be a great chaos, for example. But yeah, I'm just curious to understand if you had any appeal or something for these two freezing models.
Yeah, there are two differences. The soft freeze, that is something that exchanges do, and sometimes banks institutions do that as well. If they know that there will be a freezing order, they already secure the assets and block an account prior to the formal order to freeze it. That is not based on any law, but just on the cooperation between authorities. And to get a more formal way of performing with this, under the new directive that is being discussed within the European Union at this moment, there is a proposal to introduce in member states a form of an interim measure, which would be a more formal form of these soft freezes. Then for the additional freezing of assets under the freezing orders, it would be especially the case in orders that are sent for value-based confiscation. So if a court order from another member state says we have identified that the proceeds of this crime is €1 million, and so for the confiscation procedure, you can, probably the prosecutor can freeze up to €1 million of assets, and they have identified one bank account in the Netherlands, and they sent a request for us stating in the certificate that the freezing order is aimed at the amount of €1 million, and the reason they sent the order to the Netherlands is that they have seen one bank account in the Netherlands. Then we see that this freezing order is the aim of the freezing order is to freeze €1 million, and if this bank account does not contain €1 million, you have the possibility to freeze more assets than just that one bank account. So it is within the scope of the freezing order to also look for other assets to cover the amount of the freezing order.
sorry, can I ask something upon it? I mean, and as affected person, how I will know if you will, like, which is the written part? I mean, if I want to appeal this freezing order, the decision on the freezing, so I will be for the 1 million or for the 3 million that you extra found? Because I mean, it's just something that you discuss, and I mean, you understand what I mean?
We would
which
go
is
up
the document that I will appeal like affected person. Will it be communicated to me that you will freeze something more, or I will remain to the first freezing order, incoming freezing order, that it's saying I'm targeting the 1 million, and after I would find out that in my bank account was the 3 millions, for example, freezed?
No, it's the other way around. We would be able to look for other assets if the bank account does not cover the 1 million. So if there is like 10,000 euros in the bank account, and we see other bank accounts as well, or maybe real estate in the Netherlands, we can offer the issuing authority, you are looking for 1 million euros. The bank account covers about 10,000 euros, but we have other assets in the Netherlands as well. So there's still within the range of the 1 million euros of the freezing order, there is the possibility to freeze other assets to try to secure that 1 million euros.
This is important, in my opinion, also, to give this possibility to extend to
And with yes, and then with regards to how is the person concerned informed, the person concerned will be informed of which assets are frozen in the Netherlands based on the freezing order, and also then it's communicated which possibility this person has to appeal to these decisions. And in the Netherlands, they will be able to appeal to the execution of the freezing order if it's being recognized under the correct grounds, and if the correct formalities have been executed in the Netherlands. And then the other parts should be appealed in the issuing authority. This the issuing of a freezing order for that 1 million euros. That won't be a part of the appeal procedure in the Netherlands, but in the issuing state.
Okay, thank you. Anna, is okay? Okay, Matteo?
Maybe I can add one thing to what Jan-Elise just said regarding the soft freeze. Some FIUs have the authority to request banks to block accounts for a certain period. The Dutch FIU hasn't got that authority yet. There's no legislation coming, and it gives the possibility for the FIU to request a bank to block the bank account for 5 days. And within that period of 5 days, an MLA has to be sent to the Netherlands, or a freezing order to make it just as the way it should be. It's only a soft freeze requested by the FIU, and the freezing order or the MLA is the real freezing.
So this is about your proposal to introduce a kind of urgent, not freezing order, request.
But the problem is that the FIU cannot contact exchanges. And we all know that our clients often deal with cryptos. So we need something for cryptos. And this is why our proposal is that we can contact exchanges with a request for a soft freeze. Our message that we will send an MLA or a freezing order within an X amount of days.
Yeah, okay. In order to avoid that the money is...
Because otherwise the cryptos will be gone. By the time we send an MLA, there are so many days left after the action day, the cryptos will be gone.
Yes, sure. Okay. Matteo?
Hi, thank you both for your detailed presentation. I noticed that the states that send mostly confiscation orders are Germany and Belgium, according to what you said. And in general, it seems to me that there is a sort of geographical pattern of proximity also in other presentations. So confiscation and freezing orders, it seems to me, mainly come from near states. And so my question is, why is that? This is because you have more established investigative groups or agreements that are parallel to the European instruments and everything that allow you to cooperate more on that, or the drivers are others. Maybe criminals have more assets in these near countries. So what's your opinion? Also, not yours, but everybody's opinion about that.
I think one of the reasons is really practical, is that they cooperate in these areas where there are many countries near to each other, and it's really easy to stay off the radar longer if you're not just acting in one member state. If a part of your criminal activities is in another member state, it's for law enforcement, it's more difficult to see the complete picture and to act closely to each other, but not in just one member state is the most easy in neighboring countries. And especially within the Netherlands, there are a lot of Dutch people just living outside of the Netherlands, across the Belgian border or the German border, because houses are more cheap there, or the taxes in Belgium are nicer than in the Netherlands. So these regions are even in the legal community are mixed a lot. So you see that with criminals as well, that they cooperate across borders a lot. There are certain cases with Dutch criminals that use explosives to steal money from how do you say that? Geldautomaten? ATMs. They will drive from the Netherlands in an expensive Audi to Germany, there steal the money, and then drive back to the Netherlands. So it's not easy for them to be discovered, and then they can act longer without being discovered and prosecuted for what they're doing. And we don't see the assets that are in Belgium or Germany. They can enjoy their assets without us seeing it. So it's a really easy way for them to do it.
Okay. My opinion is also important the issue of the victim, no? Article 30 of the regulations is a very important issue, and it is nice the proposal to have a kind of a guide and book. No? This can be also one of our output in the end of our research, no? A practical guide in order to facilitate the cooperation, to know each other, to facilitate. Okay, other question? No?
Ciao.
Ciao. Thank you so much. And now, we have Poland, Minister of Justice, Dr. Lukasz Rosiak.
Hello, my name is Lukasz Rosiak, and together with Przemysław Szymański, we represent the Ministry of Justice in Poland. And now we try to share our presentation.
Why we are not able to see you?
We have some technical problems that I cannot turn the camera on this moment.
Okay. You have to be authorized to share your slides. maybe Amalia
Yes, yes, of course.
No. Are they authorized? No, because are they?
Yes,
Why?
yes, they are.
Why
They are
does it
authorized.
work?
I don't know. Now you can see the presentation.
Yeah.
Okay, thank you.
You're welcome.
Okay. Next slide, please. Okay.
Maybe
thank
as
you.
a presentation in the.
In Polish criminal proceedings, the issue of property security is regulated by Chapter 32 of the Code of Criminal Procedure. If a defendant is charged with an offense for which or in connection with which a fine, pecuniary benefit, forfeiture, compensation measure, return to the victim or another entitled entity of the financial benefit which the preparator has derived from the committed offense or its equivalent. The enforcement of the decision may be secured ex officio on the property of the defendant if there is a justified fear that without such security, the enforcement of the decision will be impossible or significantly hindered. Next slide, please. Ex officio security may also be provided for the enforcement of a decision on the defendant's property on court cost if there is justified fear that without such security, the enforcement of the decision in this respect will be impossible or considerably hindered. The security on property shall be immediately revoked in whole or in part if the reason for which it was applied to a certain extent case to exist or if reason justified its recovering even in part arise. Next slide, please. In the crime department, the Organized and Corruption Bureau of the National Prosecutor's Office in Poland doesn't collect practical data obstacles on legal issues arising during the implementation of this regulation. The local departments were contacted the Department of Organized Crime and Corruption of the National Prosecutor's Office to provide relevant information on this subject. Next slide. From the answers received, it appears that in the majority of the subdivision, there were no preparatory proceedings underway to answer the questionnaire. Next slide, please. For example, for instance, the Silesian Regional Division of the department, referring the question 24 of the questionnaire, report that he had used to the court atlas, pointing out the website was opaque and injured, resulting in difficulties in identifying the competent authorities and an incomplete translation into Polish. Next slide, please. The Lublin branch of the department informed that it applied the regulation in one of the cases concerning Article 204 of the Criminal Code in connection with Article 65 of the Criminal Code, in connection with Article 20 of the Criminal Code. Next slide. Thank you. With the framework of the indicate investigation, the object of the seizure was a property with a residential building located in Denmark. estimate value about 94,000 euro. In this department's subdivision, used judicial cooperation tools in the form of the Judicial Atlas and the Judicial Library. No reference was made to possible difficulties in their use. It should therefore be presumed that such did not occur. Next slide. Thank you. Detailed responses from the Select Prosecutor's Office. Detailed answers will be presented on the basis of data obtained from the Regional Prosecutor's Office in Gdańsk. And the data will be presented as part of the answers to the individual questions of the questionnaire on the application of the regulation. Next slide. Question number 1. Answer. In the Regional Prosecutor's Office in Gdańsk and subordinate units, there have been registered 9 cases of application of this regulation. Question number 2. There was 3 applications to foreign authorities. 6 applications were received from foreign authorities. Question number 3. Referred to 1 application to France, 1 application to the Czech Republic, 1 application to the Republic of Lithuania, received 2 applications from Austria, 2 applications from Germany, 1 application from Hungary, 1 application from Estonia. Thank you. Question number 6. Regional Prosecutor's Office in Gdańsk. The request from the Regional Prosecutor's Office in Gdańsk was made to French and Czech Republic on the activities of more than 60 capital or personal-related companies commercial law operating in the European Union, including Poland, the Czech Republic, Slovakia, Cyprus, the Netherlands, as well as outside the European Union. Most of the group income was derived from illegal gambling activities and invest in the fuel, hotel, restaurant, real estate development, medical and IT sectors. Elbląg District Prosecutor's Office, the basis for the issuance of the certificate by the Republic of Estonia was the crime of fraud involving the sending of false information between business partners, as a result of which the bank account of Polish citizens received money in the amount about of 34,000 euro, which he was not entitled to receive and was paid by him, as a result of which the Estonian company suffered damage. Regional Prosecutor's in Gdańsk, District Prosecutor's Office in Gdańsk. An application from Austria in a case of professional fraud qualified, an application from Hungary in a case of fraud against a company, application from Germany in a case of fraud against company, application from Germany in a fraud case, application from Austria in a fraud case. Regional Prosecutor's Office in Subs, the basis for the issuance of security certificate is under Article 286 of the Criminal Code. The perpetrator, by misleading the victim as the investment opportunities, led him to an unfavorable disposition of property by transferring money to a designated foreign bank account. Regional Prosecutor in Gdańsk, continuation. Question number 7. In all the applications mentioned, the freezing of funds in bank accounts was a request. Question number 10. Question number 10. In no one, except for the case of the Elbląg District Prosecutor's Office, acting as an executing authority, recognition was not denied. Safeguards freeze of funds have not been executed due to the lack of funds in bank accounts or transfer of the request in accordance with the jurisdiction to another prosecutor's office. Question number 11. The Elbląg District Prosecutor's Office did not secure for the Estonian authorities procedural funds in the bank account of Polish citizen, as these funds were subject to blocking under the decision of the prosecutors of the Elbląg District Prosecutor's Office. Subsequently, the decision of the prosecutors of the Elbląg District Prosecutor's Office on material evidence ruled that the money located in a bank account held in favor of Polish citizen would be returned to the wronged party after this order became final. Question number 30. Yes, the Regional Prosecutor's Office in Gdańsk has applied a regulation on mutual recognition of freezing and confiscation orders twice. Requests were made to France and the Czech Republic to secure the suspect's property located in France and Czech. The Regional Prosecutor's Office in Słupsk has applied to Lithuania for a preservation order. Question number 14. From 1 to 5 times. Question number 22. Not approach. In this case, the European Judicial Network would be approached. Next slide, please. Thank you. Question number 24. Question number 24. Yes. Have you ever just used one or more of the aforementioned tools? Yes. If yes, have you encountered difficulties in using them? No. Please provide a detailed answer. In the Regional Prosecutor's Office in Gdańsk and subordinate units in any case in which it is necessary to use instruments of international cooperation in criminal cases, international cooperation tools on European Judicial Network sites are used, such as the Judicial Atlas, the Judicial Library. No difficulties were encouraged in using the indicated tools. Question number 25. The role of Eurojust in the application of the regulation is no. Next slide, thank you. Question number 33. In the applications that were received by the District Prosecutor's Office in Gdańsk, in 3 cases, the local jurisdiction of the prosecutor's office was incorrectly identified on the basis of incorrect data on the bank's headquarters. Question number 50. It is not possible to provide an answer due to little experience in the application of the regulation. Next slide, thank you. Question number 51. Providing an answer is not possible due to little experience in applying regulation. Question number 52. Providing an answer is not possible due to little experience in the application of regulation. And question number 53. No data are available regarding the gender of the person subject to the orders. No difficulties in this regard. Thank you for listening.
Thank you so much for this so clear and specific answer to the question. So there is no many case in the application of the, and what is interesting that in this case are involved only bank accounts until from these reports. Maybe this is okay. The implementation of the regulation is in all in the beginning, no? Maybe it is until now in the Polish experience. It is more easy to try to phase a bank account directly. The management of other assets can be more complicated. Maybe, I don't know. This is my question. How, in your opinion, are involved always only bank account? And there is a question of somebody other. Have a question?
I just would like to add. Oh, I'm sorry. I will turn my camera on.
Yeah.
Oh, yeah, that's great. I would just like to add that we are still in contact with those who have give us the information to complete the form. We are also in contact with those who do not give us an answers. Unfortunately, we have a lot of problem with getting a response. And we are trying to make the prosecutor understand how important it is to get the problematic examples, because they don't want to share it with us, because it's our, Polish mentality. They don't want to say that we don't want that they do not can do something, or they have some problems. And this is very, very hard to break the wall and just talk to them and, hey, give us examples. We need to work on specific cases. We need to do it because we want to be better. And I think this is the main problem with implementation this regulation in Poland, that we are not talking about the cases. Because, and that's what you say. Yes, I think the freezing the bank account is something the easiest way to do. And this is why we are have only these examples. I think there are more examples from Poland with another things, but they don't want to share it with us. But we will try to do our best and get something maybe freshy to the form, and when we meet together we can discuss maybe some new cases. But we try, but we have a lot of problems with that. Yeah.
Thank you so much in any case for the effort to gather the information directly from the authorities involved. Other question? Okay. I suppose that we can do our break for
Professor,
lunch.
one last question. Thank you.
Yes, please.
Thank you, Professor. I was wondering whether, also in light of other previous presentations, I see maybe a more general problem in collecting and gathering statistical data about application of the regulation, both active and passive. I see the clash, maybe, I don't know, the last presentation told us about this Polish mentality and prosecutors who are not aware, or maybe don't want to share full information. And I was wondering whether this also not only in relation to Poland, but in general, how it is related to the secrecy of, especially at the preliminary stage of any criminal investigation, and how this can affect all the reporting and sharing of information and information about the application of the regulation, because I think it's an important general point, especially if there is the danger, the risk to undermine the results of a criminal investigation at the preliminary stage. This, I think, is a general point that deserves to be delved into. I mean, in general perspective, not only related to the Polish experience that I think you this was what you were referencing to when you said this Polish mentality. But I think it's not just Polish that has to be faced in a general way. I mean, if we want to have clear data and I mean, to know through concrete examples and cases, is important that as these two competing interests has to be balanced, you know. Otherwise, we are not going to get much. This is what I think. Thank you.
Yes,
Thank you very much.
I think that could be a problem, but we try to do something about not only this topic, but all general to collect the data. I think that the computerization and the automatization in the collection of anonymous data can help here. We're trying to introduce a system with that, so everything what the prosecutor is doing is going to the system, and the system is getting it to the central one without data. So we can only collect, you know, whole data without the specific cases. Maybe when we have a lot of data, we can just there make something more interesting about it. But we are just introducing this system, so it takes about years and years to how it will work, and we can collect a lot of data and make some analysis in Excel and etc., etc. And I think it will be helpful, but we need some time.
Okay.
To add just a very, very quick point before lunch, when we asked the Hungarian authorities to provide us with some data, the officer that we have spoken with told us that he felt not comfortable because the request was coming from someone that was external to his institution, and he suggested us to disseminate the survey through EU channels in order to get one of its superiors to command him, to order it to answer. Meaning,
yeah, but the Polish case was the Ministry of Justice. Yeah, it was an office.
That should count. Yeah. But you know, it's also a problem of authority and hierarchical order, I would say, also in this case of Hungary, and I don't know in Poland. But there's also this thing.
Yeah, that is true. And last point that I would like not to forget is the problem that also Anna said, that in Germany the real estate register is organized by property and not by the name of the owner. This can be also a problem in the cooperation, because in order to find the assets to confiscate.
The problem of beneficial ownership.
And yes, that's absolutely. We have also to stress this aspect. Okay, now we absolutely demand the lunch break, an hour of break. Okay, we see you later, 10 to 3. Okay, with a bit of late. Okay, have a good break and lunch.
Yes.
Later. Bye. Okay. Now we have Spain. Is Francisco here? Or Portugal? Joan?
Yes, yes, I'm here, but I'm still waiting for Elio.
Ah, okay. Okay. So maybe we can, the other, yeah, participant. Okay. Maybe we can start with Romania, Set Recovery Office. Okay. Perfect.
Hello.
Hello.
Maybe Amalia can help me with
Yes, of course.
my presentation because
yes,
the button is not active.
But can you send me the presentation?
But you can activate my button from my menu.
Okay. Yes, sorry. Just a moment. No, it's because I don't see your name in the participant.
Anna, if it's the name, or
but you are already authorized to share the presentation.
not because it was disconnected. I am not now authorized. Or I can send you the presentation right now.
As you prefer, because actually you are among the people who are already authorized.
I already sent it now.
You sent me? Yes, okay.
Sorry for.
No, don't worry.
Anna Maria, tu devi avere un microfono che entra in risonanza con qualche altra cosa ed è una cosa terribile, lo devi spegnere, purtroppo tu devi avere due microfoni che si entrano in risonanza. Lo vedo perché si illumina continuamente il tuo quadro e tutti noi sentiamo un rumore enorme. Quindi tu dovresti, mentre parla qualcuno, spegnerlo.
Potremmo spengere.
Sì, no?
Sì.
Sì. Ecco. Adesso è un'altra cosa.
It's okay. Thank you. So, the national report from Romania. We'll start with the statistical data which we collected until now. There is not a full vision about this statistical data, but we will receive another set of data in weeks which will come. From General Prosecutor's Office in 2021, we had receiving freezing orders from another states and recognized 51. The number of freezing orders received from another state and executed was 45. The number of freezing orders received from another state that were refused was 1 order. The average execution time for recognized orders was 3.5 months. In 2022, the number of freezing orders received from another state and recognized was 43. The number of freezing orders received from another state and executed was 38. The number of freezing orders which were refused was 4. And the average execution time was from 5 days to 3 months. It's a long time between them. But real statistic data we had from our courts, the number of confiscation orders received from another state was 9 in the entire period of regulation in which we applied the regulation 1805. Germany 2 recognized the orders, Sweden 2, France 1, Belgium 1, Slovenia 1, Croatia 1, and Austria 1. This is the confiscated confiscation orders. And the number of confiscation orders received from another state and partially recognized, 1 from France, 2 was refused from Italy and Bulgaria, and 1 of the freezing orders received from another state, it was withdrawn because the debt was clean after this procedure. The number of freezing orders received by courts and recognized by courts were 6. Italy 2, Slovenia 2, France 1, and Austria 1, and 1 were refused from Spain. So this is our statistical data. The ultimate data is about the freezing orders recognized by prosecutors and appealed before judges, because we have this statistical also. In Romania, first, when the criminal file is in an investigative phase, the recognition of orders or freezing orders is in competence of the prosecutor. So, if the interest persons want to appeal that orders after communication, these appeals will came at the judges, and our statistics it's I'll present that Belgium has 9 orders, appealed orders, France 7, Spain 7, Germany 3, and Italy 2. 1 partially admitted for Belgium and 1 totally admitted for Germany. So, in conclusions about statistical data, regarding the freezing orders addressed to prosecutors for recognition, although we have all the statistical data, we cannot at this moment present the reason why the recognition was rejected, because we don't have access to the relevant documents. As already mentioned other speakers, we have the same problem because investigative phase of the criminal file is non-public, so we don't have access to this data. But we can ask, and we asked our General Prosecutor's Office to mention what are the reason to why they refuse some orders, and we hope until the end of October to obtain that responses. Thus, the activity of recognized freezing orders take place mainly during the criminal investigation phase. In this context, we cannot have access to those files, as I already mentioned. As respect for the freezing orders and confiscation orders addressed to the courts for recognition, we know that the data collection was difficult because the courts do not have a clear record of this type of cases. During these years, the courts didn't send clear statistics to the Minister of Justice regarding the number of cases in which they were entrusted with the recognition of freezing and confiscation order. However, because I am a judge and I'm seconded in our office here in Romania, which is ANABI, I have access to all the judicial decisions in an electronic format. So by using search criteria such as 2018/1805 number of the regulations, we were able to identify all the judgments where the courts referred to the regulation. So even if our courts didn't respond to our questions, I think we have a clear data, statistical data about what orders, freezing orders or confiscated orders were recognized, but we don't now have the data about their execution. Another conclusions it's about that the statistic at the European level can be improved if the member states in the European Parliament will support Article 26 on the proposal for a new directive on asset recovery confiscation. In Romania, from 1st of October 2023, this year, after 1 week from now, the RoArmis electronic register will become operational, which will include all the seizure and confiscation order, including those issued by or recognized under the regulation. RoArmis, which is an integrated national IT system, electronic register for recording claims arising from crimes, which includes, among other things, information on the different stages of the recovery process, starting with the first phases of identification and tracing the assets, followed by seizure of the proceeds of crime and other types of property, and ending with the implementation of the final procedure for the execution of special or extended confiscation, security measures to repair the prejudice, the conclusions of international agreements of the sharing of assets resulting from crime, on the decision on the reuse or confiscated property in the public or social interest. So in these public registers and also an electronic one, we will have the entire map of assets which are freezed or confiscated in real time. Romanian representatives in COPEN meetings, because I was the national expert which were represented Romania at that meetings, at the negotiation to the new directive, supported the importance of the Article 26 and the necessity of having such a provision, bearing in mind also that the need to overcome practical obstacles and to harmonize the implementation of regulation, of our regulation 2018/1805. Unfortunately, I want to say that majority of the member states have expressed their opposition to the mandatory establishment of such registers at the national level. If you know the directive, the proposal now it's on the trialogue, which means that we have a final proposed from Council, and now it is in front of the European Parliament. And now the European Parliament rediscussed this Article 26 again and want to to become mandatory that provision for all the states to have a national register, maybe an electronic one, because we have the technical service which is needed. But I want to say, maybe you can convince your representatives there to support that. It was a very minimum support. Romania and maybe other two countries, whole Dutch, I think, colleagues from Dutch were support this decision. I want to say that according to Article 19, the executing authority may decide not to recognize or execute a confiscation order only where, for example, at the B letter, there is a privilege of or immunity. Now, I will present some practical cases in which our national courts didn't recognize the freezing or confiscation orders. It was one file in which, in the case of recognition of a confiscation order in equivalent, the execution is carried out according national legislation of the state who recognized the order. In Romania, the executions of the confiscation order take place in the form of a fiscal enforcement. However, the provisions on the prescription of tax claims are not applicable in the context where national legislation expressly established that the security measures, including confiscation by equivalent, are not time-barred. Thus, although the first court initially rejected the request for recognition on the grounds that the claim was time-barred, the appeal was admitted and the confiscation order was recognized because the conclusion is that confiscation, it's not time-barred, there's not prescription for this measure because there are security measures. Another case was in which the National Court partially recognized the confiscation order, the reason for refusal being represented by the constitutional principle of the more favorable criminal law. The security measure of extended confiscation is highly repressive. Since it is a criminal law sanction, it is subject to more favorable criminal law provisions. In the case law of the Romanian Constitutional Court, it has been established that the provisions relating to extended confiscation are constitutional insofar as extended confiscation does not apply to property acquired before the entry into force of law number 63 in 2012. In this context, the Romanian court did not recognize partially the extended confiscation order by the French court in the context where one of the immovable assets indicating the confiscation certificate was acquired before 2010. So it was a constitutional principle in which Court of Appeal, Cluj Court of Appeal rejected partially the confiscation order. Recognition of the confiscation order was rejected on the grounds that the asset had been sold prior to ordering of the confiscation measure in the requested state. As my colleague from Bulgaria said, it was the same case. Of course, they are different people, but it was the same reason. And I think this case was in cooperation with Bulgaria. The order was issued by Bulgarian state. The asset has not been, in this case, the asset has not been previously seized by the authorities of the requesting state, an aspect that once again underlines the importance of ordering freezing measure from the beginning of criminal investigation, as well as urgent recognition of them. Another practical case, it's about that we need to particular attention must be paid to the competence of the bodies that recognize the freezing orders. The recognition of freezing orders is carried out by competent authorities from the requested state according to national law. And according to Romanian national law, during the criminal investigation phase, the freezing order is disposed by the prosecutor, which implies that he also has the competence to recognize the freezing order issued by foreign authorities, even if, according to the legislation of certain state, such as order it is under the jurisdiction of an instruction judge. We had this problem in some cases because the orders in other member states were ordered by judges, instruction judges, but in Romania the recognition will be done by a prosecutor, because we are in a investigative phase. Regarding translation costs, if the Romanian courts wanted to translate the confiscation order as well, and it's a common practice to do that in Romania. Yes, we have the translation of the certificate, but the courts want to analyze the entire document, the entire order. So if the Romanian courts wanted to translate the confiscation order as well, and not just by the certificate, the costs were covered by the public budget. There is no specific provision on this effect, but the general provision that provide from the payment by the state of all translation costs are applicable in our cases. Thank you, and I can respond to your questions if you have one, maybe more.
Thank you so much for this interesting report. There are three aspects for me very interesting, also very issue. When the confiscation order is time barred in a member in the national legislation, is it always possible to apply in Romania? Because in your legislation it is not relevant that the crimes is time barred. Because I think not that the problem when the crimes time barred, the problem has to be managed, no, dealing with the legislation of the issuing states, no, or the executing states, no?
Yes, I understand that, but in that case, we will recognize your order and we will execute it, because we cannot analyze that fact in our legislation. And the interest person can challenge this order in the issued state, because we can judge that matter in our state as an executional state. Therefore, in that case, the interest person will invoke prescription or time barred in the issued state. It's not a problem for the executional state. We will execute.
But in this is what is not clear for me. In the legislation of the issuing states, was it possible to apply the confiscation order even if the crime was time barred?
That's the problem in the issued state.
Yeah.
So
yeah.
We will execute. We will execute because we can't challenge in executional state that problem. The person who asset will be affected will have the opportunity to challenge that in the issued state.
Okay. Okay. Another aspect that is very interesting is the problem of the retroactivity of the more favorable law, because this is a case when it is possible the refusal because in order to apply, because there is a violation of a fundamental rights. If we consider the retroactivity of the more favorable law as a fundamental right, this is not so clear. It is clear that the principle of irretroactivity, the principle of the retroactivity of the more favorable law in the last, also case law of the Court of Justice and the European Court, the trend is this, that is also a fundamental right. This is also a very important aspect. And another important aspect, in my opinion, is the problem of the prosecutor and the judicial authority, because in many states, in the end, the confiscation order has to be apply, has to be recognized by a judicial authority. No, so it is impossible that the prosecutor can apply an urgent freezing order, but the judicial authority has to recognize. So this is an important issue. Maybe it is the trend also in the new directive is this. The new directive is less clear than the directive, because in the new directive there is always the possibility that the authorized, a competent authority applies the freezing order or the confiscation order, and it is not specified that it is necessary it is not so clear, the recognition of the judicial authority. But okay, question? If there aren't questions for you, I thank you so much, and I give the floor to Francisco for Jimenez Villarreal Fernandez. Thank you so much for the General Prosecutor Office of Spain for his report, his speech. Thank you so much. We are not able to hear.
Yeah, now can you hear me?
Yes, yes.
Yes. Hello, good afternoon to everyone. Good afternoon, Ana Maria. Sorry, because I was in a meeting. We have an annual meeting of prosecutors specializing in judicial cooperation, and I have just arrived home, and now I can be with you. Yes, I have a report, but it's not finished, and we are also dealing with the questionnaire. It's not easy because there are many statistical data that are not available so far. As you know, in Spain, the competent judicial authorities are mainly the investigating judges, but in any case, judges and courts. They are the responsible to transmit this information to the Ministry of Justice. At this point, we have figures that are not really reliable, even in relation to the number of freezing orders, for example, that we have received. If you compare the statistics from the prosecution office, because we are receiving freezing orders, you compare it with the statistics from the General Council of Judiciary, there is a gap. We have more freezing orders that we receive at the prosecution office that the total freezing order that the judges are executing, and that is not logic. And also in the questionnaire there are plenty of questions that are really focusing on the details, member states, issuing member states, also the type of the model of confiscation, and so far we don't have statistics or data in relation to that particular aspects. Then for us it's difficult to answer. We can answer with the information that is stored in our case management system in the prosecution office, and we can inform on the freezing and confiscation orders or certificates that we are receiving at the prosecution office, but you don't have the complete or the global overview with that information. Then we have a piecemeal information, and that is something that I have to say from the very beginning. In general terms, the situation and the title of this webinar is what are the practical obstacles and legal issues arising from the implementation of the new regulation. In general terms, I have to say that we have an uncertain scope of application because the regulation that is directly applicable, as you perfectly know, and in force since December 2020, the situation that we have is that this regulation, the judicial practitioners are applying it directly, but at the same time we have an outdated legal national legal framework with a law on mutual recognition from 2014, where this law is a sort of compilation with the different transpositions that we have been doing during the last 20 years. And in this law, we have a title 7, and is on the mutual recognition of freezing order, and Title 8, that is on the mutual recognition on confiscation orders. But these two titles of the law are reflects the implementing legislation that we have in place, but the implementing legislation of the replaced framework decisions 2003 and 2006. And of course, there are a lot of rules and provisions that are not in line or fully in line with the regulation. And then for the practitioners, this is not the best scenario to deal with the application of the recognition of the freezing and confiscation certificates that we are receiving. This is the first thing that we have to underline. We are still waiting for legal updates. We had a bill last year from the International Cooperation Unit of the General Prosecution Office. We submit a report to the General Prosecution Office on this particular bill, but as we had early elections this summer, we have a new, we are now dealing with a new possible government and a new parliament, and this bill is over. Then we have to start again all the legislation making process. And of course, we have this new law, or updating the existing law, still will suffer more delays. Second thing, well, civil confiscation. Civil confiscation orders are not envisaged in our legal system. Then the concept of proceedings in criminal matters, as provided in the regulation, and is not a equivalent concept to criminal proceedings, as you already know, of course, but we are still waiting for a clear case law from the Court of Justice of the European Union, because sometimes practitioners, for them it's not clear when they receive a pure civil confiscation from mainly from a legal system that is in line with the Anglo-Saxon legal systems, and to distinguish it with, for example, freezing orders coming from Italy, that is not exactly the same case. It's not a civil confiscation issue in a civil proceedings, but a preventive measure that is linked to a criminal proceedings. And for the practitioners to have a clear guidance, to have a clear overview of, about this particular issue is still very, very complex. Territorially speaking, we have also a piecemeal approach, because The framework decision 2003 is still applicable in relation to Denmark. And we are still receiving freezing and also a request for evidence assurance from this country. At the same time, we have to issue this framework decision when we have to ask for freezing and evidence assurance in relation to this country. In relation to Ireland, we have to use Council of Europe conventions for this purpose, when we have to issue freezing orders. At the same time, with Denmark and Ireland, we have still in place framework decision 2006 in relation to confiscation orders. Of course, United Kingdom is still there, and we have the trade and cooperation the Trade and Cooperation Agreement in force, the TCA. I have to refer to the United Kingdom because the question is, well, what about Gibraltar? Gibraltar is under or close to Costa del Sol, and we have a lot of money laundering cases. And what is the legal framework applicable to this rock, to Gibraltar? And we don't have a clear also answer for this, because TCA is not applicable according to Article 1.3 of this agreement with the European Union. And we don't know if in relation to freezing orders, because in relation to evidence gathering, we know that, and we have very clear that is applicable Convention 1959, but in relation to freezing order is not the same regime, and we don't know if we have to use United Nations conventions. Then all the scenario is uncertain. All the scenario need to clarification, additional clarifications. On top of this, we have the main regulation features. Mutual recognition is based on standardized forms. There are cases that we have to refuse formal forms from the framework decisions because it's mandatory to use the Annex 1. We have very, very short deadlines, and some of them are not really feasible, mainly in relation to freezing of real estate and properties. And we try to deal with this issue of the possibility or impossibility or main difficulties in relation to the execution of freezing orders. I have to underline that the main practical bottlenecks that we have is the execution of freezing orders by investigating courts that are in what we call hot zones and hot areas in Costa del Sol, Alicante, Balearic Islands, where the level of case files that they are dealing with is very high, and to comply with these short deadlines is really challenging in many cases. From the prosecution office, we try to smooth as much as possible. When we receive the freezing orders, we send it immediately to the investigating courts with a very clear report in relation to the main legal issues, whether there is a ground for refusal or not, underlying the legal framework that is applicable in relation to the remarks I have already made. But still is difficult for investigating courts that are in Costa del Sol mainly to deal with the deadlines. And at the same time, we have we try to underline our practitioners that there is no joint proportionality test. Then proportionality test is something, is a task for the issuing authorities, because some of our colleagues still apply the regime that they have for the European investigation order also to the regulation, and it's not the case. And the issue of translation, we don't admit English even in urgent cases. Then all the certificates should be translated into Spanish. And in addition, Spain made a declaration, and incoming freezing and confiscation certificates should attach the relevant national legislation. And I think as other countries and other member states, I think that Italy also made the same declaration. Spain, we have to ask for this underlying judicial decision, the freezing, the domestic decision, when we receive the certificate. It's not necessary to translate it, but in principle, we can ask for the original or a certified copy, but this additional document is needed for any recognition or, of course, execution of the freezing and confiscation orders. In relation to the Spanish issuing authorities, well, freezing orders is under the competence of investigating courts or judges that are in charge of the criminal proceedings in which the measure is to be adopted. Then could be during the investigation phase, the investigating courts, or during the trial phase, the trial courts and the second instance courts. And also the European delegate prosecutors in relation to PIF crimes is competent in accordance with the EPPO regulation and our domestic legislation, adapting the Spanish legislation to the European Prosecution Office. With regard to confiscation orders, the competent authorities are the trial court in charge of the enforcement of the sentence. With regard to freezing orders, from the executing viewpoint or standpoint, the executing authorities are the investigating courts where the property to be frozen is located. And as regards to confiscation certificates, the first instant trial court where any of the property to be confiscated is located. But Spain made a very relevant declaration when to the EU institutions, because these are the legal authorities already provided in our mutual recognition law, but also the International Cooperation Unit of the General Prosecution Office is competent as receiving authority when the location of the property is unknown, and perhaps also the residence of the person who is affected is not known in relation to confiscation certificates. Then we have another layer or another type of receiving authorities to be added to the executing authorities, and that declaration is very useful, because when do you know exactly where is the asset, or do you know exactly to which concrete authorities have to be sent the certificate, you can always refer it and send it to the International Cooperation Unit of the General Prosecutor's Office. And this is also something that is very practical, because sometimes it's not easy to know which is the competent authority in Spain. And we have also two different courts dealing with freezing orders and with confiscation orders, depending on because the investigating judges are there, but also the first trial courts. If you have any difficulties to find out who is the competent authorities, you can always send it to the General Prosecution Office, to the our unit, International Cooperation Unit of the General Prosecutor's Office. Yeah, and in relation to the main regulation novelties, of course, we have the advanced restitution of frozen property to the victim when the title to the property is not contested, Article 29, and the preferent and direct compensation of victims before the disposal between issuing and executing authorities or states, properly speaking. And in relation to this is a quite important novelty for Spain, because we had it in place in our legal system before. The regime that it was provided in the framework decision 2003 and 2006 was not really were not really in line with our legal system. And now we feel more comfortable, but still we have many questions about the scope of application of these novelties, because of course the concept of victims should be defined in accordance with the issuing authority, and that is in recital 45 of the regulation. But still there are questions about the concept of civil confiscation, the concept of we call civil responsibilities, and when to use, when is adequate to use the certificate or not. I leave it that question in the air, but this also we have been discussing precisely this in the meetings that we had yesterday and this morning. There is a question in the questionnaire about when is the EIO used aimed at gathering mainly banking information or financial information. Well, and in relation to this, we have a clear concept of the EIO as a legal instrument to be used for the gathering of evidence. But sometimes there is a confusion between the provisional measures provided in Article 32 of the EIO directive and the freezing orders, properly speaking. And we receive a lot of EIOs asking for banking information and at the same time for the blocking of the bank accounts. And of course, that is not possible. And we have to answer the issuing authorities, recommending them to issue a simultaneous or additional freezing order for that purpose. But well, sometimes it's not very clear blocking of bank accounts, whether blocking of bank accounts always needs a freezing certificate. At least stemming from the experience that we are gathering as our receiving authorities. In any case, coordination or simultaneous execution of EIOs and certificates needs to be in the forms that we are using. In the EIO forms is not provided any section for this, and we consider that perhaps Section D could be a melting pot, a place where you can also fill in that you are issuing as a freezing certificate at the same time. And also in Annex 1, perhaps in Section B, related to the urgency, and Section D of Annex 1, you can also fill in indicating that, well, you are at the same time asking for financial investigation, for banking information, but also issuing a certificate. We hope that in accordance with the leg referenda recommendations that the General Prosecution Office made in the last annual report, prosecutors in Spain will be in charge also, or under the scope of competences, we will have the powers to execute freezing orders and to, if possible, to receive all the freezing orders, because this legal reform will really smooth the execution and recognition of freezing orders, and we will be in the situation to overcome the current situation, at least in relation to urgent cases. As in line with the proposal for a directive, last year's proposal for a directive, I think it's in Article 11. I don't remember exactly. Is envisaging the possibility for the AROs, no, to confiscate. But well, in Spain is going to be a little bit shocking, no, that if the AROs have this competence and not the prosecution office. But it's something for the future. In relation to assets tracing and financial investigation, there is a possibility in our mutual recognition law when it seems that the assets are in other member states, the prosecutor can ask for a financial investigation in order to localize these assets. For this purpose, of course, AROs are very useful. Also, networks like CARING are very useful, and my impression is that are underused. Specialized prosecutors knows about CARING and even AROs. This morning, one of the responsibles, the deputy director of the ARO, Assets and Management Office in Spain, ORGA, was telling us that they receive quite a few number of requests for tracing of assets, and that is something very surprising for us, because they were set up 7 years ago. This office, this ARO, and also it's very important the use of spontaneous exchange of information as provided in Article 7 of the 2000 Convention, and the prosecutors are in the best place for this spontaneous exchange of information. And also there is an underuse of what we call the consultation procedures. We have a lot of windows for consultation procedures in the mutual recognition legal instruments, including the regulation, the 2018 regulation, but practitioners are not really using this, all the benefits from the consultation procedures. And in relation to the previous financial investigation, I think is a very good example of this lack of use of consultation procedures that you have also in the EIO legal regime. Finally, last but not least, in relation to financial investigation, there is also an lack of use of JITs, Joint Investigation Teams, set up just for this particular purpose. I'm not going to speak more about spontaneous exchange of information, but I would like also to underline other tracing of assets difficulties. Mainly, all of you know these difficulties very well. Difficulties related to identification of the beneficial owner of the criminal assets, limited use of the competences for financial investigation units, lack of central bank's account register, and also lack of central register for beneficial owners, company beneficial owners. Also, the concept of the right to be heard of the third parties, including the right to be held by the holders of bank accounts that still is in place in many legal systems, and when they receive a freezing certificate, like the case of Austria. The financial privacy, that is a concept that need to be clarified. We have very interesting judgments at national level, and I can provide you with this information, but also at EU level, I think that there are also interesting judgments stemming from the Court of Justice of the European Union, for example, in the case of Coty, Germany. Another difficulty is related to the identifying of proceeds of crime converted into virtual assets. This is even more tricky. In relation to the issuing a certificate, I made a reference to the need to use the freezing Annex 1. Also, that cannot be adapted or modified or simplified in any way. So far, under the Spanish legislation, you can accept an equivalent document. An equivalent document, that Article 19 of our domestic law is not in line with the regulation. This is an example of one article that we have to reform. In those cases, well, we have to start a consultation procedure, and so far, all the situations that we had were solved at a preliminary stage, and a mere consultation procedure allow us to overcome that difficulty. In relation to the attached documents, I made a reference also to the need to receive the judicial decision. I have a table. I have to send you the PowerPoint presentation with all the countries that ask for an additional document to be attached. And also, I have in the same table a relation with the member states that are using central authorities for the transmission of the freezing certificate. And I don't know what is the reason. Maybe is an impact of the COVID-19 period that we suffered years ago, but it's interesting to see how many countries are using central authorities for this transmission, transmissions through central authorities. I have a list, and I think there are 7 countries, 7 member states that introduce the need to transmit or the certificates throughout these central authorities in a mutual recognition regime where, in my opinion, should be direct transmissions between judicial authorities, the golden rule. I don't want to bother you with more issues. I would like to refer to 2 case studies. I have 2 interesting case studies in relation to, the first one is related to the possibility to suspend an operation that is a suspicious operation. You know that in accordance with the anti-money laundering legal framework, financial investigation units, FIUs, are allowed to suspend provisionally and at an administrative level operations, banking operations. They have a direct contact with the other FIO in the affected member state. This, in the case of Spain, during a month, 30 days, this operation, this transfer is suspended or postponed. It's interesting to see what is the relationship between these administrative authorities and the judicial authorities, because we receive and it's a very concrete case, a freezing order from Lithuania asking for the freezing of the bank account already, and the operation was already suspended by the FIU in Spain. They need a judicial ratification, an extension of this suspension. We receive it at the prosecution office at the Audiencia Nacional. The prosecution office at the Audiencia Nacional sent it to the prosecution office in Malaga, because the bank office was in Malaga. The prosecution office in Malaga, in the very same day, received the certificate and sent it to the investigating court on duty. Surprisingly, we had disagreement in relation to the competence between the investigating court on duty and the ordinary investigating court in Malaga. When they finally decided which investigating court was competent, the deadline was over, and the 20,000 euros were away. Okay? Then this is a very good case study on what are the difficulties that we have with this judicial chain in relation to this freezing of bank accounts transfers when we receive it from the FIUs as a suspicious operation, and the need to improve the judicial response also from our side. And the second case is a case, is a Spanish and Italian case. In principle, the investigation was from PPO Milan, and we received a confiscation certificate in 2019. The anti-corruption prosecution office in Spain was in charge. Well, the confiscations affected or was related to properties, state properties, vehicles. Previously, these assets were seized in Spain by virtue of MLA requests, were previously sent in 2013. The crime investigated in Italy were tax fraud and punishable insolvency. The Italian issuing authorities indicated in section K of the certificate that any asset located it takes the form of an order to pay an amount corresponding to the value of those specific goods. Then they were asking for a value-based confiscation, but when they asked for the freezing of these assets, and despite the value-based confiscation was not provided in Framework Decision 2006, this model's confiscation was enforced in Spain up to the amount of 36 million euros, and was recognized and executed in Spain. But the thing is that, well, this was a very complex criminal proceedings, because it took a lot to reach the final confiscation decision. And the freezing of real estate was carried out as a preventive measure under the form of a provision of disposal in Spain by the different investigating courts affected, mainly in Tarragona. In those cases, also, they asked for the lifting of the corporative veil in accordance with the Spanish legislation, Article 20 of what we call Ley Hipotecaria. Then with a case with a lot of legal challenges and difficulties, but at the end, all the assets were there, were frozen. When we received the final confiscation order, we were in the best position to execute it.
But it was not a case of the application of the regulation, because it was over 2019.
Yes, it was. But the prosecution office, because what at the end of 2019, beginning of 2020, they apply partly the regulation in order to execute it.
Okay.
And I am going to tell you in which particular point, because it was discussed whether bona fide third parties were the right of bona fide third parties was respected in accordance to the regulation, and also they discuss whether there are victims in Italy and whether they have the right to be compensated in accordance to the regulation. Finally, this wasn't an issue, but the discussion in accordance to the application of the regulation was in the consultation procedures. Then the regulation was, the shadow of the regulation was there for the application of this, for the enforcement of this freezing and not freezing, confiscation certificate. At the end, they managed to distribute 3 million euros, then 1.5 million for Italy, 1.5 million for Spain, for the Spanish Treasury, respectively, and the case was finally closed. And in principle, that 50% split wasn't cleared at all, since it was a tax crime and punishable insolvency case, and the Italian authorities could discuss whether there are or they were victims in Italy or not. But finally, the Italian prosecution office accepted the 50% distribution approach, and with any further discussion. And this is a case that is in the limit, but was also affected by the regulation. That is from my side, all from my side. I will send you the PowerPoint presentation, and also we are willing to complete and to answer all the questions of your questionnaire. Is not easy, but at the same time, I must say that it's very, very interesting. And thank you also very much for submitting us this questionnaire that is a challenge for us, but also a good opportunity to see what are the weak points also in the application of the regulation in Spain. Thank you so much.
Thank you so much, Francisco. Really interesting. You spoke also about the general problems in the implementation of the regulation, the difficulties in the interpretation of proceeding criminal matter, and so on. These problems are always present, but also other practical problems. The problem, for example, of the translation in Spanish language, and the necessity to attach the original order, the problem of identifying proceeds of crime converted in virtual money to simplify some procedure, or the connection with joint criminal investigation, or the IO, and so. And this is also for me very important, the aspect of the consultation procedure. This is an aspect to emphasize, this can be important to facilitate the implementation of this aspect of the regulation. And also the role of the asset management area, asset management. This is also another aspect that we will focus also on this aspect in another step of our research next year. Okay, this has been a very rich report. Are there some questions? No? Nobody? Okay. We can also analyze a complex case in the next workshop in 29 in Milan. Also, so if there aren't other
if you allow me,
yes.
Anna Maria, there is an issue that this issue pop up during the discussion that we had this morning. Is in relation to third-party rights.
Yes.
And also third-party and persons affected.
We will have another workshop specific about also these aspects, third-party rights. Yeah, because this is a big issue.
Okay.
Also in the Italian, yes, it is a real big issue. The third rights party, also the management of the assets in order to protect also third-party rights, the protection. Yes, this is a very important aspect, but I suppose that we can better focus in the next.
Okay. Then.
Okay. So now we have other two reports by Portugal and by France. Are ready by Portugal?
Yes, I think so. Yes.
Yes.
I think so. Good afternoon, everybody. Thank you once again for giving me the floor. Briefly, just to say a few words before giving the floor to my Portuguese colleague, Hélio Rico Rodrigues. Portugal, like almost all countries, has a problem with statistics. This is a general problem, but this is also a problem related to the regulation. Regarding the regulation, it's worst. There are no official statistics. There is no internal law, and so nobody knows very well what to do and what is going on. We have the data of the ARO, but they are mixed with some other information, some other requests of cooperation, judicial and policial cooperation. So they are not reliable. We also have the data of the judiciary, but once again, they are mixed with other data, namely with the European Investigation Order. In our case management system, there is no autonomous register for the regulation. So all the international cooperation is registered in the same field. So it's very hard to have some reliable information from there. To have a clear picture of the problem, one have to go to court by court. And at the moment, this is very difficult because we are coming from the summer holidays and everybody is concerned with other issues and they are not, they don't answer our questions as brief as we wanted to do so. So we are still waiting from data. We have already collected some data, but we are waiting from the majority of the data. As far as we already know, we had a very interesting Italian case, if I can say so. It's regarding a preventive measure, an Italian preventive measure, and it was they issued a freezing order that was executed in Portugal without any problem, and this is I think a good example of mutual recognition. Regarding to civil confiscation, as far as I know, there is no cases. The doctrine is prepared to recognize the civil confiscation, no matter where the decision comes from, if it is related with a penal case. If it is purely civil, if it is a purely civil issue, in this case, we are going to refuse this case, but only when they are purely civil and no matter where the procedures comes from. We have also, we can already clearly notice that we have more incoming requests than outgoing requests. And for me, as I said this morning, it is related with training, at least the Portuguese situation. If my Portuguese colleagues don't know how to recover assets at the national level, how are they going to recover the assets at the international level? So I think we have to train more people, and then we can hope that the level of international confiscation will rise. And having said that, I give the floor to my Portuguese colleague, Hélio Rigo Rodrigues, because he has more than me to say, because he's collecting the answers that we already have, and so he can give more, he can speak more about the issue. Thank you very much.
Thank you. So we wait for the answer to the questionnaire for more also details, data from Portugal. Hello?
So hello.
Okay.
Good afternoon, everyone. It's a pleasure to be with you again. As João already said, as João already mentioned, it was not possible to collect statistics directly from the computer system that is used to manage the criminal case. And that is a huge problem, it's a huge difficulty, which makes it almost impossible to embrace a more in-depth analysis of the relevant data, the relevant statistic, and also the relevant problems that exist within the enforcement, the application of the regulation. So in order to overcome that, as João also said, I try to contact directly, to call to some of my colleagues that work in the most relevant investigation departments at the national level, from the south to the north, and ask them for help, ask them for some inputs in this regard. We haven't received many contributions yet. It's not possible to make a clear overview of how things work in practice. But even so, I was able to get some ideas, some perceptions, how things might be in practice. For now, it's just some ideas, some perception. It's worth what it's worth, but at least it's something. And the first interesting that I was aware of, and it was a very positive and a very happy thing that I could understand by speaking with colleagues that work in practice and issue this and apply in enforcement in practice this regulation, is it's related with the type of crimes which the certificate is based. It was a very good surprise because I had the perception that many of the certificates that are issued from Portugal as an issue state and from Portugal as an executing state are crimes against property, and the crimes against property just stand out, especially fraud, scams, theft, and robbery. Obviously, there are requests based on other type of crimes, and money laundering and drug trafficking, but crimes against property, especially online scams, they stand out. And it was good news because the regulation should not be used just for more complex cases. It's not just for corruption and very complex money laundering cases. It should be used in very simple cases, in everyday work in criminal investigations. should be used every time that it's a need to cooperate somehow within this regarding asset recovery. So it was a good news. But the fact is that in crimes against property, there is always, at least almost always, an identified victim. And this often raises one problem. That is the problem to use the mechanism that is provided within the regulation to the assets returned to the victim. And it seems to me that this is an aspect that deserves special emphasis and special attention. Why? Because some of my colleagues with whom I speak, they raise some difficulties in this regard. Of course, none of those difficulties that they speak about lead to a refusal to cooperate, but still they deserve some attention. And with this regard, with the return of assets to the victims, the first difficulty, the first problem that I think it's important now to be pointed out, it concerns to know whether it's necessary or not for a prior judicial decision within the execution state to return the property to the victim. It has been pointed out by some colleagues that certain states, certain member states, certain execution states are demanding a provisional confiscation order. Provisional confiscation order, whatever that means, whatever that is. I'm not completely sure what that means, but they reported that some executing states are demanding that in order to be able to return the assets to the victim. Well, there are probably some differences of understanding between member states regarding the expression that is provided on Article 29 when it refers to the obligation to restitute the frozen property to the victim. Probably this concept of frozen property needs some clarification, and these working groups, these projects, can be also very useful in this regard. The second, and in my perspective also very relevant question that is raised by the colleagues, the prosecutors, mainly prosecutors that I have been speaking with, it's the definition of the member state that should pays for the cost of the returning assets to the victim. And this is not a small issue. If a piano, something that it's very worthy, if a piano is located in Greece and the victim is in Portugal and the piano should be bought from Greece to Portugal, who will pay for that? I think that Article 31, and it's not just my difficulty of understanding on this regard, I think that Article 31, it's probably not enough to solve this problem when what is at stake, it's the return of the assets to the victim. The question is how to understand in this regard the expression that's established on this Article 31 that each member state should bear its own costs resulting from the application of this regulation. It's not easy in these cases to understand exactly how member states, how the executing and the issue states should solve this problem when what we want is to simply return that specific assets to the victim. It's not a value-based confiscation, it's just a specific asset that belongs to one victim that was by the commission of a crime brought to another country and that just need to be returned. So we'll pay for that. And some colleagues face this problem in their everyday work, and I think that is not so small problem that should not deserve our attention too. Well, as far as for the execution of the certificates, I don't have a lot to report, and no specific problems, no major problems were reported regarding the execution in Portugal from the perspective of Portugal as the execution state in relation to the regulation. It has not been indicated any grounds for refusal ever been applied in Portugal, either from the perspective of Portugal as an issue state or the executing state. The colleagues with whom I speak about this, they don't report any case that they ever faced the refuse to execute the certificates. But from the perspective of Portugal as an executing state, the only difficulties that have been pointed out it concerns with the specific functioning of the legal regime in Portugal. This is because the competence, the power to enforce, to apply a specific precautionary measure, such as seizure or freezing, can belong to the judge or to the public prosecutor, depending on what is at stake. If the confiscation if it's a confiscation of assets in specie that is involved, the competence for the seizure will rely on the public prosecutor. But other way, if it's a case of value-based confiscation, then the enforcement of the freezing, it will fall to the judge. And that specificity may raise some problems to determine in Portugal who must do what. So it's therefore essential that the certificate, when it's sent to Portugal, it's filled out in as much detail as possible regarding the type of confiscation that is at stake and the relationship or the connection or the link between the assets that should be freezed or seized and the crime that has been investigated in the requesting country. And some colleagues sometimes they speak about some difficulties, some lack of sufficient information in the certificate that allows them to understand if it's a confiscation in specie or if it's a value-based confiscation that is at stake. On the other, another important topic that the colleagues also highlight is the issues that concern the jurisdiction within the national execution state. And the possible division of the request between different various courts in the executing state, namely in Portugal. That happened at least once or twice. And it's a problem that has been identified and should be also given some attention, at least here. There are cases that the requests of the freezing, the sets are located in different parts of the execution country, in different parts of Portugal. And in such cases, what is appropriate is that a single court, the single judicial authority to carry out all the freezing or seizure in respect of all the assets, regardless their location. And this is the rule. But we have seen cases when judges believe that they just have jurisdiction to execute, to freeze the assets in their own territorial area. And that means that conducts to the result of that understanding that I don't think that it's the most accurate one, but the result of that is that the same request, one single request, can be executed by different judges for different assets, depending on that asset's location in the territory of the execution state. And that can lead to some problems on the efficiency of the freezing measure that the issue state wants to see enforced. Well, finally, and like João also said, there are very complex cases that request execution at several steps and be taken in a specific time and specific date, and that have been carried out without any problem or without any hitch. So we don't have any major problem with more complex cases and execution of more complex cases. Well, regardless of that, it should be also noted that the colleagues that work in that most complex cases normally use the intervention of Eurojust or even the CARI network. And that allows them for an adequate coordination between the different states. And that's a very helpful solution that colleagues in many cases go by. And on the other part, there are also probably some other specificities of the Portuguese system that can explain why we don't feel many difficulties or many problems in the execution or issuing the regulation. Because at this moment, almost all the investigation departments have a contact point for international cooperation, and that contact point helps with issuing and execution requests, namely in filling the certificates and in checking if everything is in order to be issued or executed in Portugal. Nevertheless, and finally, it's clear for the perspective that I was aware of when I speak with a lot of colleagues about this, that it's need to raise awareness about the application of this regulation. It's very important to raise this awareness among judges and prosecutors. And although no major difficulties have been pointed out, have been identified, I think that all member states have the obligation to encourage and training and capacity building for judges and prosecutors to apply this regulation properly. That's a long way to do and a lot of work to do in this regard, in regard of capacity building and in training of judges and prosecutors. But so far, the fact that no one of the colleagues with whom I speak raised any major problems, it was very good news. And if you want any other insight or clarification about what I just said, I'm here at your disposal, and thank you for your attention.
Thank you so much for this survey of the Portuguese situation. There is always this problem with the victim protection, the rights of the victims. This issue came back, no, in about each report. Is a very big issue, and also in the end also the importance of the training of the competent authorities in order to build the mutual trust, because I have this feeling that until now each member state, the judicial authorities are not so have not a real feeling of mutual trust, but there is a bit of a difference, no, in relation to the other legislation. In order to guarantee it, it is important also the fundamental rights. Are there some questions? Issue? No. So maybe we can conclude with the French report, and after we have also another interview of an expert, Dr. Verardi. But before, if Dr. Verardi can wait, we can have the last report by the French representative, Arnaud de Blesson. Thank you so much.
Hello, everybody.
Please.
Thank you very much. I am Arnaud de Blesson. I'm legal officer at the Office for Mutual Legal Assistance in the French Ministry of Justice. Unfortunately, the French expert for this project, which was supposed to be Professor Cutajar, will no longer be able to work on this project. So I'm going to give you some data that are available to us at our level at the French Ministry of Justice, and some tendencies on the basis of the statistics that we have, and from the informations that are available to us. So basically, in order to give you these statistics, we have the annual reports of the French public prosecutor. So this is our basis for the different datas regarding the transmissions of the freezing and confiscation certificates within European Union, excluding Denmark and Ireland, for the regulation of 2018. Unfortunately, this annual reports cannot give us the opportunity to answer to all the questions that were in the questionnaire. So I will just try to give you the more informations I can have. So first of all, what we need to have in mind is that in France, according to articles 619, 95, 97 and following of the Code of Criminal Procedure, a freezing certificate is ordered by the prosecutor because the decision to freeze the asset can be ordered by the investigating judge or by the prosecutor, for instance, but the freezing certificate is written and delivered by the prosecutor. So it's the prosecutor that will deliver the freezing certificate when he needs to have a seizure made on the territory of a member state. So regarding the execution of freezing certificates, it is the prosecutor or the investigating judge, according to the same articles 695, 9 and 11 for the disposition of the Criminal Procedure Code. And regarding the confiscations, we have to notice that it's the prosecutor's office that delivers the confiscation certificate on the basis of the judgment ordering the confiscation. And finally, it's the prosecutor's office that is territorially competent that receives the confiscation certificate issued by the competent authority of the requesting state, and it delivers a decision of exequatur so that the confiscation can be made in France. So just having this in mind, I will just give you some datas, or at least the more relevant datas that are available to us. Because as you know, for the application of the regulation, this is the principle of direct transmissions that applies, which means that as central authority, we don't receive these certificates of freezing or confiscation, which means that we have no perspective over what it becomes, who delivers it, when, how, nor on which assets, nor on for which crimes, and so on. So for us, it's difficult to give you an exact state of this kind of certificates at our level. But thanks to the annual reports of the French public prosecutor, we have the public prosecutors from the different regions of France that give us the most relevant, or at least the data that they can give us. Basically, we have two main datas that are available, that are the number of freezing certificates or confiscation certificates that are delivered or received by the French jurisdictions. So regarding freezing orders, as issuing authority, the French jurisdictions has delivered 89 freezing orders. which is quite a lot, regarding the freezing orders that are received, because there are only 24 freezing orders received by the French jurisdiction based on the certificates of the European jurisdictions, member states. As you can see in this domain of freezing orders, the French jurisdiction are issuing around 3 times more freezing orders than what they receive. We can see, especially from the year 2021, that there has been an increase of the number of freezing certificates that are delivered, because in 2021 there was only 41 freezing orders that were transmitted by the French jurisdictions. So to give you a little perspective on this regarding the countries, so these freezing orders are mostly with Germany, with 9 delivered, 6 received, with Belgium, 10 delivered, 3 received, with Spain, 25 delivered, 3 received, with Portugal also, 15 delivered, 3 received, and Poland with 8 delivered and 3 received. So that was for the freezing orders and the certificates. Now looking at the confiscation orders and certificates. So as a delivering authority, the French jurisdictions has delivered 6 confiscation orders, while they received 5 confiscation orders and certificates by the member states' competent judicial authorities. So in this domain of confiscations, we can see that the flows are quite balanced. And for confiscation, it's essentially with Belgium, with 1 delivered, 1 received, and the same numbers with Spain and Netherlands, except for Romania, with 3 confiscation certificates delivered. So this is mainly the stats that are available to us at our level. So it's difficult to say if there has been some specific investigations that have been carried out beforehand, as the European investigation order, for instance, because the EIO are transmitted directly between the competent requesting and requested judicial authorities. So it's not transmitted to our office. So we don't have appreciation of the flows, of the kind of crimes, the kind of assets, and so forth, and nor the number of EIOs that are necessary to have the informations for issuing a freezing certificate. So that's it for our perspective, sorry. But what we can say is that it appears that in many cases, an EIO is delivered first in order to identify the assets that could be seized, to investigate on the origins of the assets, for instance, on the origins of the transactions, on the bank accounts, for instance, on the accounts holders, etc. Also, the joint investigative teams can also lead to the elements that can allow to deliver a freezing certificate. So, of course, these are the tendencies that we can observe in a very general way. But what is also important to notice is that the French judicial authorities are rather aware of the practical tools for judicial cooperation that are available on the website of the European Judicial Network, But even if they are rather aware, they still need indications or precisions for identifying the competent authority, for instance, especially for delivering a freezing or confiscation order. So we can be asked by them in order to help them to identify it properly by the atlas, judicial atlas of the EGN website, for instance. Because there is a real difficulty to identify the competent judicial authority requested when the French requesting authority doesn't know the location of the asset to be seized or on which bank account, for instance. So this is a real difficulty in the practice. This is less a difficulty for confiscation orders, as the location and the competent judicial authority is already identified most of the time. So the problem is more at the level of the freezing certificates, the delivering of freezing certificates. Again, what is sure is that we don't receive these certificates. So if we receive it, we invite the French judicial authority to transmit it directly according to the regulation. We have guidelines to help the French judicial authorities in redacting and transmitting the certificates in order to guide them if they have difficulties. And so, as I told you, from all these elements, we don't have precise statistical data regarding the models of freezing orders or confiscation order certificates for 2022. And from what we have available, the seizures are usually requested for real estates, for bank assets, or for valuable objects, for movable property, for instance. So what is interesting also to notice is that most of the time it's for in procedure for a fight against tax fraud and economic and financial crime and organized crime in general, regarding the so-called lucrative crime. So this has for the tendencies and the kind of crimes for which the freezing certificates or confiscation certificates can be delivered or received, but mainly delivered regarding to the statistics I gave you. I'm also going to give you some positive points, because I think even if there's of course ameliorations that can be given, it's good also to see the positive points from the regulation, because we have the French jurisdictions that gave us their thoughts on the recent tools within European Union. So what they told us is that regarding this regulation of 2018, especially with regard to requests for mutual criminal assistance in combating tax fraud or economic and financial crime, some public prosecutors' offices reported us that the simplification of freezing requests from one judicial authority to another has made it possible to act more effectively in blocking sums transferred to foreign bank accounts, often with rebound accounts within the European Union. So this is, I think, a very useful point that can be underlined. The simplification that makes it more effective for blocking the sums in question. And so this was the main positive point that was given to us regarding the application of the regulation. However, regarding the problems that still exist, it has been noted that the processing time for these cases is problematic, given the speed of the transfers that can be made by the suspects, so that the seizure of the sums held in these foreign accounts may prove ineffective. This difficulty is compounded by the need to translate the freeze certificate, and in some cases, the order of the liberty and custody judge, which delays the official transmission of the freezing certificate by several days. So it has been noted that this formality runs the risk of dissipating the sums involved in the freeze. However, this observation is tempered by the fact that some countries allow the request to be sent provisionally in French or English, and thanks to the intervention of Eurojust, the sums can be safeguarded. Sorry. So again, the intervention of Eurojust has been lauded by the French judicial authorities in this kind of situations. But still, there is these problems of delays and translations, as it has been also indicated by most of you today. So that's why, as recommendations, a number of public prosecutors from France argued that maybe the translation difficulties could be reduced if some high-performance automated translation tools were made available to all judicial authorities within the European Union. So again, how it could be made, it's another question, but this kind of automatic translation tools that already exist in some domains could be useful for the translation of the certificates in order to gain and win time, variable time in urgent cases, for instance. So this is maybe a question that could be useful to see, regarding also, of course, the security of this translation, and of course the level of confidence we can have regarding the specificities of these procedures and the technicities of the words. That is not always very easy to translate in first instance. So if you have any kind of questions, I'll leave you the floor. However, I just wanted to tell you that I will leave my position at the French Ministry of Justice by the end of next month. So it's my last workshop with you all. Again, it was a great pleasure to share these workshops and your experience and these very interesting questions. So I hope I will see you in the future. Unfortunately, not in Milano in November.
Thank you so much. We are very sorry that you cannot in the future collaborating with us, but you can always collaborate if you want as in any case researcher or judge in your role as an expert over the subject, even if not in as a representative of the Ministry of Justice. Thanks so much for this presentation. It is, if I have correctly understood, I would like to ask you, have you said that there are 3 times more cases of as an issuing authority than as executing authorities in France? So this means that there are more cases when the French authorities ask for the recognition of a French confiscation order or freezing order, then
yes, this is for freezing orders exclusively. So from the statistics we have, as I told you, 89 freezing orders delivered by the French jurisdictions in 2022 against 24 received from member states' competent authorities.
This
So
is
it's-
interesting. No, also about
Yeah.
the knowledge of the regulation of the French authorities. No, this means that.
Yeah, I think also it can depend of the procedures, because maybe there's procedures that needs more seizures. So necessarily in the datas it impacts, but again, we don't have more precisions. I guess also that it's maybe a domain that is evolving in France. So there's more and more procedures that needs seizures, freezing certificates. So it might explain these numbers.
Yes, thank you. Also, this idea with the translation, automatic translation, I don't know. It can be a solution. There is the problem of the technical language, but in any case, this can help, because it would be easier if there is a European language, no? In order to avoid the problem of translation only one language, because this is always a problem, and it is a not so big difficulty, no? The problem of translation, but in the practice, this is a problem. Are there some issues?
If I may,
yes,
I would like to have a clarification regarding a point that is similar to one we maybe raised in previous interventions. That is, you mentioned the use of EEO and other instruments given by Eurojust mainly to exactly understand if there's a possibility to come to a confiscation, to a sort of something like confiscation or freezing, if I understood correctly. I wanted you to just explain a little bit better this thing, if it exists, if I well understood. And in that case, also some cases that you have, one case that you have about that would be interesting to understand how these different instruments, the regulation, the orders, and the instruments from Eurojust just overlap and contribute to the same goal or to similar goals.
Well, what I can tell you is that, as I said, the problem first is to identify the assets that could be saved, for instance. So in order to get this identification, first you need to, most of the time, you need to deliver a European investigation order to the competent authority from the EU member state, so that it can make the investigations to identify clearly, for instance, the origin of the assets, the origin of transactions that the French judicial authority cannot do because it doesn't have the data for that at this disposition. So he will ask his European counterpart to make these investigations, and when he will have the result of these investigations and that he can identify the assets, for instance, or the bank account, the precise bank account, I mean, then he will deliver the freezing certificate so that the sum in question can be seized, for instance, in view, if confirmed, in view of confiscation, for instance. I hope I answered your question, but
yes, but and then the question becomes who decides whether to execute to record to the European investigation order. There is an automatic launch of the investigation order, or is the prosecutor that decides how we could, improve the launching of European investigation orders to trace the assets of criminals, let's say.
Well, as it is in the phase of investigations, most of the time it can be the investigative judge, but it can also be the prosecutor, because they are competent for delivering European investigation orders. And regarding the results, they will make a decision for freezing, and then it's the prosecutor that will write, redact, and deliver the certificate, the freezing certificate.
Okay.
Thanks.
Okay. One of the issues is always that is the problem to identify the competent authority. It is, in my opinion, this problem is possible to overcome easily. Also, if as output of our research, we try to offer kind of guidelines, which are the competent authorities for each member states, no? In order to avoid the problem. The problem is when it is not clear where the assets are. This is a big issue, no? You know that there are some assets in another country, but in the freezing order, it is not specified where. In this case, it is very difficult without a central authority to identify the competent authority, no? Maybe in each member states, it is necessary to identify a kind of a central authority which is competent for the implementation of the regulation, or for this case of cooperation, in order to avoid this problem. But it is also a bit difficult, no, to freezing order without the identification of the assets, no?
Yeah, and that's why most of the time the French judicial authorities deliver a European investigation order first, so that they can have these elements to identify after the competent judicial authority to issue the certificate. But there's also something interesting, is that when the French judicial authorities are executing a freezing certificate, and in case, for instance, the freezing certificate that is received doesn't contain clear determination of the localization of the account, for instance, it is the Judicial Authority of Paris who will receive first the freezing certificate.
Okay. Yes.
So as an executing authority, that's how it works in France. It's if there is no clear determination, by default it will be Paris, but again, in order not to lose time for Paris, for instance, in identifying the competent authority and so forth, it's better to have proper tools to identify clearly the competent authority that is territorially competent regarding the localization of the assets, for instance, or the bank account or so forth.
Thanks so much. Okay, now I have the pleasure to give the floor to Dr. Berardi, who is a judge in the section for preventive in the Tribunal of Reggio Calabria, in the section of preventive measure, and who has experience in the implementation of the regulation as issuing authority. No, Dr. Berardi?
Yes.
Yeah, okay.
Yes. Good afternoon to everyone, and thank you, Professor Samogeri and all promoters for the involvement in this RECOVER workshop about implementation, the practical implementation of the European Union regulation of 2018. According to the subject you gave me, and showing some slides, I make a short introduction about our work as judges of preventive measures in general, and then we will deal with some cases in which the Tribunal of Reggio Calabria found obstacles in execution within the European Union borders. I'm Giovanni Berardi, as Professor Samogeri said. I work as judge in Department of Preventive Measures of Tribunale di Reggio Calabria. Try to share the slide. And as you perhaps know, we issue both personal and preventive measures, and they are related, the preventive measures, to some limitations of freedom. Financial measures are instead like freezing or confiscation orders, and they are decided at the end of a due process and a trial with a chamber hearing. Can you see correctly slides?
Yes.
Okay. As we know, in the case of financial measures, it could arise lots of questions during the execution phase if goods to keep are outside national borders. In the case of goods situated in the territory of the European Union, it comes to application regulation of 2018. Otherwise, other international conventions or bilateral agreements rule the matter. Regulation of 2018, as we know, introduced the principle of mutual recognition, very important, of freezing and confiscation orders without other further formalities. If a crime is included in the list of Article 3 of regulation, for instance, participation in a criminal organization, hot topic here in Reggio Calabria, then order of freezing and confiscation will be applied without the verification of double criminality. If it's not in the list, the application is subject to the incrimination according to the law of the executing state. To come to our case studies, we know that rules are provided for by an European Union regulation. That means that they have a legally binding and directly application for every member state of the European Union. So that means that if a member state refuses to give execution to a freezing or confiscation order or of another EU member state, it is possible to apply at first the European Commission and then the Court of Justice for the infringement proceeding according to Article 258 of TFCU. To that regard, among cases of Tribunale di Reggio Calabria with obstacles in execution within the European Union, we can surely refer to an execution procedure in Malta in 2022. In May 2022, our department decided to notice the European Commission because the state of Malta didn't give execution to our order of confiscation. Order that was issued surely by regulation founding on regulation of 2018. After the decision, Eurojust, also thanks to the involvement of Dr. Spezia, today's speaker I saw, contacted the authorities of Malta in order to avoid an infringement proceeding And the authorities of Malta decided to carry on a dialogue directly with us, with the Tribunale of Reggio Calabria, with the aim of giving execution at the Italian order in the following months. They asked, in particular, this is very nice to note, to issue a new certificate directly addressed to persons who resulted to be the formal owners of goods that actually were owned by the person affected of confiscation. So the suspected was the substantial owner of goods, but then the formal owners were other persons. So at the beginning, Tribunale established that the real availability of the goods, according to our law, was referred to the person suspected, and so issued a decision only towards him. But Malta then, basing on principle of protection of property, requested also a new certificate directly addressed to the third formal owners of the goods. Accepting this request, then Tribunale finally issued a new certificate that was directed to formal owners. And now we are looking forward to have finally good updates from Malta. Another relevant case that you find here is the case faced by Reggio Calabria in 2023, so this year, and it was about the execution of a freezing order in the territory of Germany and Hungary. In these territories, there were headquarters of some companies that were managed by Italians suspected to be part of a criminal organization. In that case, we had executive problems related to promptness, to rapidity of execution, and finally to the end and the good result of the freezing order in general. Indeed, as referred by Procura of Reggio Calabria, a first certificate based on regulation was issued on March 2021, following, of course, a freezing order. Judicial administrators then came to Germany to check assets of the companies, but German bank didn't give any assistance, stating that the bank accounts were not already blocked. Eurojust so asked to Procura to specify some details in order to let this procedure more fluid, and to specify details of bank account, and Procura sent the requested information, and now we are waiting for updates also in that case, and also in the light of a preventive measure.
In the end, the money disappear.
Yeah, that's the bad end of the story. Like you can see here in this slide, within the same execution procedure, suspected tried to create a real chain of confusion, chain of mess. In the meanwhile, an Italian company, I try to simplify here with this name, with these letters. Let me please tell me if it's not clear. Italian company A transferred money to another Hungarian company B. Company B opened a new bank account in Hungary. However, the financial operation continued to be managed by the Italian company A. Then Italian company A was acquired by another company C, Italian, and it opened an Italian bank account, but without transferring money from Hungarian bank. So the money was here, there. Following judge orders, judicial administrators tried to send a request to Hungarian bank asking the credit transfer of money for the new Italian bank account. But the bank in February 2023 answered that the account was not blocked and was already closed in December 2021. without giving any other information about the destination of money. So, as Professoressa Moggiari said, the money are away. We don't know where, but we have tried to solve with Procura and to try to find a solution with Hungary and Germany, and Eurojust, of course. Going to conclusion and to stay within the 15 minutes, we can say that a rapid and close cooperation to overcome obstacles in execution within European Union borders can be considered the most important goal, in my opinion, to reach in the framework of implementation of fight against illicit assets. There are different kinds of values, as we saw, for instance, for the protection of property in Malta, the protection of third parties, the formal owner, and so on. And we have a lot of different kinds of systems among the member states of EU, a distance concerning also necessary time to execute orders. But then promptness and rapidity, and most of all willingness, remain at the end the most relevant basis for a real solidarity between member states of European Union. So thank you very much, that's all, and thank you for your attention again.
Thank you so much, Dr. Berardi. I would like to say something more about the role of Eurojust, because in some speech today, there was this, somebody spoke about the role of Eurojust. I suppose that is very important when there are some obstacles, some difficulty also in the identification of the competent authority. Eurojust is trying to help, has an important role to simplify it, to solve the problem. So can you explain us which role Eurojust had or has in this case?
Yes. We usually have a constant relationship with Eurojust, and this body has a very, very central role for our cooperation. And for instance, a concrete example is the case of Malta I spoke before. In the case of Malta, the intervention of Eurojust was decisive. Otherwise, we had sent a real communication to the Commission, to European Commission, and so the role of Eurojust was decisive because it allowed to avoid an infringement procedure and maybe an uncertain way, an uncertain path to overcome, also by us. So it was very, very decisive, the role of Eurojust in that case. And we had, following that, we had a good relationship with Malta authorities. And before this intervention, they didn't answer anymore in the previous 2 years. So it was really decisive, and it led in a few months, I remember well, in 5 months, to keep in contact us with the Malta authorities. We had some speech on Teams platform. It was very easy then to understand each other and to try to find a common way, a middle way between our two legal orders, according to the mutual recognition, but according to the different principles that we have found our legal order. Distance preventive measure allow us to keep goods substantially owned, not by the formal owner. Otherwise, Malta law doesn't give this opportunity. So in that case, to have a meeting together was really decisive, and we have to thanks to Eurojust.
Perfect.
In other cases, for instance, in the second case, in the Hungarian-German case, Eurojust tried to have to propose a solution to us, asking us to specify bank details. Then that was not enough, but we have good hope for the future.
Okay. Other question from everybody? Today, Dr. Spezia wanted to take part in our workshop, but Dr. Spezia was a member, also the head of the Italian desk of Eurojust for a period, but now in the last month, in the next month, he start in a new role as a prosecutor of Florence, but he wanted to take part in this workshop, but in the end he sent me a message that he is not able to participate today. He is very sorry, but it was impossible for him. But I would like to stress the role of Eurojust in order to sometimes to solve in a very quickly and practical way, no? In order to try to connect the authorities involved in a case and in order to find a solution. Which has been the language used in this case?
English. It was English, yes.
Yes. Okay.
To avoid any difficulties, so we directly translated before.
Yeah. Okay. Are there other question, issue, somebody would like to say something other? I would like to show in some of our presentation today, some colleagues from Bulgarian, for example, told us that they had done a kind of investigation with the colleagues with some prosecution office in the country in order to gather information. We have prepared a kind of brief questionnaire for the authorities competent in order to apply the regulation. We will send this questionnaire, but we would like only to propose this other tool in order to improve our research, but each partner can choose if it is necessary to use, if it is necessary to send this questionnaire to the authorities competent, or it is just enough the statistical data or the, for example, I suppose that in the case of Bulgarian, this research has just done. I'll try to share. Okay, this is the, can you see? Can you see?
Yes, we can.
Yes. Okay. Yes, so it is a very brief questionnaire with only some question that it is possible to send to the involved, to the competent authorities in order to have some more information, and also in a more specific way, no? Which are the ground for refusal if there are some cases which when the mutual recognition has been refuted, which are the problem with the translation, how many at which states were involved, for which type of seizure forfeiture, which type of assets, and if also legal persons are involved. We send this questionnaire. For example, we would like to also to use in Italy, but it's in the choice of each partner to improve the research also in this way. What it would be better, one of our proposal can be also try to create a kind of software where each competent authority in the beginning of a case as a suing authority or also as executing authority can introduce the more relevant information. Not only that there is a case of mutual recognition, but for which model of confiscation, which kind of assets, for which crime, no? In order to gather in easy way the fundamental information and to understand in the end which are the issue and which are the ground for refusal. This can be also one of our proposal for the future, because sometimes we have some statistical data, but we don't have enough information in order to better understand which can be the problem in the implementation of the regulation. Somebody would like to say something other, or we can conclude? Joao, maybe?
Yes, nothing to say. I think sorry, let me put my camera on. I think the workshop was very fruitful, but for the moment I have nothing more to say. Thank you very much for giving me the floor once again.
Thank you, Joao. So in the end, we are waiting for the answer of the questionnaire, and we will try also to gather the suggestion of this workshop in order to elaborate also some solution proposal. Okay, Amalia, we have to give some information for the next step of our project. In Milan, we have two important moments. One moment is the workshop in the afternoon will be about other cases in order to try to together around the table to carry on this reflection about the praxis in the implementation of the regulation, the case and the difficulties in the implementation. And in the second day, the 30th of November, it will be the first moment of official and conference to the public in order to start to share the results of our research with the external, no? So it would be important trying to involve also, for example, in Italy, I am trying to involve the Superior School for Judge in order to give the opportunity also for the judge who would like to better understand this instrument, the regulation, and to take part in this conference. Or other, I would like also to involve the association of lawyers in order to give also the opportunity to lawyers which are competent or interested in this subject to take part to our conference in Milan. So what I would like to say is that I invite each partner in the project to try to involve also online, invite to take part online the authority competent in the implementation of the regulation in order to start to share the result of our conference. So the idea is that in each partner in a brief presentation has to speak about which are the model of confiscation covered by the regulation, which are in this first praxis the problems in the implementation. We, with Matteo and Pietro, we will try to prepare a kind of survey of the models of confiscation involved in the covered by the regulation, and also it will be very useful, I suppose, to prepare a kind of survey of our competent authorities for the implementation of the regulation, as in particular as executing authorities. Amalia, please.
No, just a very simple thing that soon after the closure of the meeting, I will send you a feedback questionnaire. I'm sorry, but for this administrative task, but the EU asked us to fulfill this kind of form. And yes, this is the deadline. I can remind the deadline for the end of October for the national reports. That's it. I think it's fine. So.
Okay. So thank you so much for the participation in this workshop. I hope that it has been useful to better know each other and to improve the confidence and the mutual trust in order to increase in the end the implementation of this regulation. Okay, have a nice evening. Thank you.
Goodbye.
Thank you.
Thank you.
Bye.
Bye-bye.
Have a nice evening. Bye-bye. Bye.
Nice evening, everyone. Bye.
Bye.